Petitioner dismiss ಆಗಿರೋದು ಸೊ 2017 ವಿತೌಟ್ ಡ್ಯೂ ಪ್ರೋಸೆಸ್ ಆಫ್ ಲಾ. ಮತ್ತೆ ಅದ್ರ ಜೊತೆಗೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಬರೀ 2 weeks ಅಡ್ಜರ್ನ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರು ಸ್ವಾಮಿ. ಇದು ಟೈಮ್ ಇಲ್ಲ ಅಂತ ಹಿಯರ್ ಮಾಡಿಲ್ಲ. ಅಟ್ಲೀಸ್ಟ್ ಡಿಸ್ಮಿಸ್ ಆಗಿರೋ ಸ್ವಾಮಿ, ಏನೋ ದಯವಿಟ್ಟು ಕನ್ಸಿಡರ್ ಮಾಡಿ ಏನೋ ಒಂದು ಮಾಡ್ಕೊಡಿ ಸ್ವಾಮಿ ದಯವಿಟ್ಟು. ಸೊ
ಸೀನಿಯರ್ ಸಿಟಿಸನ್ ಇದ್ದಾರೆ, ಅವ್ರ ಮಗ ಸತ್ತೋಗಿದ್ದಾರೆ, PF ಅಮೌಂಟ್ ರಿಲೀಸ್ ಮಾಡ್ತಿಲ್ಲ. ಪ್ಲೀಸ್ ಟೇಕ್ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ. ಡೇ ಆಫ್ ಟುಮಾರೋ ಮೈ ಲಾರ್ಡ್.
ನಾಳೆ ಬರ್ಲಿ ನೋಡಿ. Who is the employer? Put it.
My lords, we have served notice 9 months back, my lords. Still the matter has not been listed from past 1 month.
Put it, date. Yes.
List 1, page number 1, 1 to 6. Page number 2, serial number 7 to 11. Page number 3, 12 to 17. Page number 4, 18 to 23. Page number 5, 24.
Serial number 24, my lords. I appear for the respondents in this matter. Lords, arguing counsel is undertaking travel. 2 weeks may be granted.
Have you informed that?
Yes, my lords. We have already informed the other side. They have
listed.
requested for a date to be fixed, my lords.
List in the week commencing from.
13th of January.
Yes.
Please, my lords.
Page number 6, 25 to 30. Page number 7, 30. Page number 8, 31 to 37. Page number 9, 38 to 43. Page number 10, 44 to 48.
Serial number 46. Pleadings are not complete in this matter. Kindly a date may be.
Inform the other side.
His lordship, petitioner himself wanted to make this
Statement of objections to be filed.
the private respondent.
Statement of objections to be filed by the respondents by the next date. List the matter in the week commencing
13th
from.
of January. Page number 11, 49 to 53.
53.1, my lord. I appear for the petitioner. I pay for 2 weeks accommodation in this matter.
Let us see it's with the connected matter.
Please,
So when it reaches, I'll accommodate. I'll make a note of it.
please, my lord.
Page number 12, 54 to 59. Page number 13, 60 to 65. Page number 14, 66 to 72. Page number 15, 73 to 78. Page number 16, 79 to 81.
79, my lord. I appear for respond number 2, my lord. But statement objection, my lord.
Have you informed the other side?
I have informed, my lord.
My lord, for the petitioner, my lord. I mean, for the petitioner in this matter, my lord.
Yes.
There is an interim order.
Interim order may kindly be extended, my lord.
An interim order earlier granted is extended till the next
Dated
date.
21, my lord.
List the matter in the week commencing
13th
from.
of January.
Please.
Serial number 74, my lord.
Yes.
I have some urgency, my lord. Only sought for, my lord, for granting promotion.
No, let us see. Let us.
Urgency is there.
Not done. Yes.
List 2, adjournments, page number 1 to 5. Page number 2,
Serial number
5. Inform the other side. At request. Matter is adjourned.
page number 2, 6 to 10. Page number 3, 11 to 14. Page number 4, 15 to 19. Page number 5, 20 to 23. Page number 6, 24 to 26. Next one, fresh matter, serial number 1. Sunil Kumar.
My lord, I have challenged the annexure F.
Yes, you take out notice. PG is directed to accept notice for the respondents. This is the matter of the winter
My
vacation.
lord, I sought an interim order because
When is the order passed?
my lord, in
When
the
is the
year
order of termination?
2000.
7/5/2020.
Because my lord, I have given.
No,
Number
correct. 4 years now.
No, my lord.
So you have to wait. I can't give ex parte where you come to the court after 4 years. I have to hear them. List the matter in the week commencing from.
13.
Yes.
Page, serial number 2, Suresh Babu Raj.
Yes. Yes.
The petitioner is the adopted son of the late Nanjunda, who was working for Bonivilas Water Supply Department, Mysore, Melot. Nanjutappa died in 2012, and he was adopted by 1995. But the adoption
Yes,
deed
you
is,
take out notice, take out.
you know,
AG
Copy to be served.
copy.
Mysore Mahanagara Palika. Arun Gaurav GK is directed to accept notice for the respondents list after winter vacation. Yes,
B. Yapish. Chennai Gowda.
For the petitioner,
yes,
I'll give you.
filing.
yes.
Good.
Yes,
My lord,
As
after the departmental inquiry,
yesterday,
departmental inquiry is there, report is there.
the same stage was maintained and the application is filed for the stay of the appointed order. Annexure A.
maybe just take me through the facts once again.
My lord, sir, the fact is that as per the annexure A, the impugned order was being given to the petitioner to terminate them. In the same order itself, it shows that the petitioner was selected as per the selection list is on general merit. Page number annexure A, my lords, 26, I think. In that selection list, serial number 33, it clearly shows that
Page,
annexure A, my lords.
yes,
16, page 16.
Selection list, my lords, page 25, my lord,
page,
25. 25. In that serial number 33,
yes,
the petitioner name, that it has been shown that
general,
general general merit / W, women's quota general merit. In the same list, above you can see that serial number 28, my lords. If the petitioner has been selected in the SC quota, it was clearly mentioned as SC because other candidates, it has been selected as SC in the same list, serial number 22. But
Yes.
here, she has selected as a GM. She has not used her SC caste, any benefit or whatever, nothing they have used in this service.
no promotion,
My lords?
no promotion on the basis. of
Promotion
reservation.
has been happened based on that after the completion of 6 months or 1 year. That has been come out, promotion happened in a normal way, not on the SC quota or whatever is there, because she has served, she has selected in 2012, around 11 years she has served this service. Based on that, she got all the increment and promotions, not on the SC quota, my lords. So this is the fact of the case and where she has been purely selected on, and additionally, the page number 16, the termination letter, annexure A, that itself shows that the second para, which has been mentioned in Kannada, ಎರಡನೇ ಹುದ್ದೆಗೆ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುವ ಸಮಯದಲ್ಲಿ SC ಜಾತಿಗೆ ಸೇರುವುದಾಗಿ ಉಲ್ಲೇಖ ಅನ್ವಯ ತಹಶೀಲ್ದಾರ್ ತುಮಕೂರಿನವರು ಪಡೆದ ಜಾತಿ ಪ್ರಮಾಣ ಸಲ್ಲಿಸಿದ್ದು, ಡಿಪ್ಲೊಮಾ ವಿದ್ಯಾರ್ಥಿ ಅಂಕಗಳು ಹಾಗೂ ಲಿಖಿತ ಪರೀಕ್ಷೆಯಲ್ಲಿ ಗಳಿಸಿದ ಅಂಕಗಳನ್ನು ಆಧರಿಸಿ ಸಾಮಾನ್ಯ ವರ್ಗದ ಮಹಿಳಾ ಸಮತಳ ಬಿಂದುವಿನ ಎದುರಾಗಿ ಜೆಇ ಹುದ್ದೆಗೆ ಆಯ್ಕೆಯಾಗಿದ್ದು. So this is based on purely, they only mentioned ಆಧರಿಸಿ. It is purely based on the marks. ಪರೀಕ್ಷೆಯಲ್ಲಿ ಗಳಿಸಿದ ಅಂಕಗಳನ್ನು ಆಧರಿಸಿ.
Let us see, I'll state, you file your objection, I'll give you liberty to move for vacation of the interim order on filing statement of objection.
My lord, I oppose interim order. She has given a false declaration stating that she belongs to SC community, my lord, on the basis of anonymous petition given to the department. Lokayukta inquired. Thereafter, she belongs to actually Goundar, my lord. That be 3A category, my lord. They dismissed on 2024, January 1 year, my lord. After lapse of 1 year, he can't, my lord, I oppose, my lord, interim order.
Dismissed on
8/1/24, my lord, January.
why do you, how do you explain the delay?
Delay, my lords, they were not aware of the approaching authority. So they thought that they had to approach the same concern authority. So they have given other letters also.
but they were not knowing.
Now, correct, now she has worked for 11 years, one. Two, her selection is in general merit, not on the basis of her scheduled caste criteria. Suppose she had, she was selected on the basis of her caste, it's a different matter.
My lord, my
I'll
lord,
have it next week, you get whatever further instructions, let us.
my lord, may I read it? ಈ ಅನಕ್ಷರ itself ದುರ್ನಡತೆ ಒಬ್ಬ ಅಭ್ಯರ್ಥಿಯು
No,
ಮತ್ತೊಬ್ಬ
that is not in dispute. We
Right.
are saying that it requires hearing. She has worked for 11 years
Yes.
and she has not been selected on the basis of her caste certificate. You
My-
file your objections, I'll give you liberty.
Additionally, my
My
lord,
lord, I will file my objections, but she has not been prohibited from taking other appointment also.
No, that's a different matter. She has worked for 11 years. She is selected on general merit, not on the basis of her caste.
My
So
lord,
to what effect her false declaration regarding caste has been taken benefit of? It's for
after
you to-
holding inquiry, he has suppressed, my lord. I am in the inquiry report. itself.
Correct, but whether it's a proportional punishment, that also we have to see. Now, suppose the candidate
My,
was selected on the basis of a caste and reserved category, then it would be okay. Now she's selected on the general merit. So even if there was a false declaration, whether the punishment of termination is proportional for a person who has worked for 11 years and not claimed any benefit, you file your objection. with.
my lord,
additionally, my lord, this
my
caste
objection
which
may
has been,
kindly be-
this caste which has been given by the parents of the petitioner when she was
That
in the
now
lower.
don't get into it. You are on weak footing on that. I'll consider it anyway. The petitioner has challenged the order of termination, wherein proceedings were conducted by the respondent on the ground of false declaration of caste of the petitioner, who had declared that the petitioner belongs to scheduled caste category. Full stop. Admittedly, even as per the governments of the impugned order, petitioner was selected on general merit basis. Full stop. If that were to be so, the question then would remain as to the proportionality of punishment as well as the selection of the petitioner was on general merit criteria. Taking note that the petitioner was appointed in 2011 and has been in service for about 12 years. Matter requires consideration. In the interregnum, taking note of the petitioner having been selected under general merit category, admittedly, and also taking note of the contention, taking note of the aspect of proportionality of punishment. There would be an interim stay of the order at annexure A. Respondent are at liberty to file, to seek for modification of the interim order after filing statement of objections. This is the matter
my lord,
immediately after winter vacation in the week commencing from
20th.
20th.
my objection. I
Third
oppose.
counsel for the respondent has opposed the grant of interim prayer on the ground that the declaration of caste is admittedly a false declaration,
And also after holding inquiry,
and that punishment was imposed after holding of an inquiry, departmental inquiry, and accordingly submits that no case is made out for grant of interim prayer.
delay also. Delay,
It's
delay.
further submitted that the petitioner has approached the court after a substantial delay. Yes.
4, Sachin BS.
Much obliged.
The petitioner, my lords, has given a representation to consider, my lords, for a time-bound promotion or a promotion.
Yes, take out notice.
Please, my lords.
AG is directed to accept notice the first respondent, Mandya Institute of Medical Sciences. So and so is directed to accept notice for respondent 2 and 3.
Please.
5,
Please, my lords. Lords, in this case, my lords,
In 2020, my lords, government of Karnataka notified the
Take out notice.
placements.
AG is directed to accept notice for respondent 1, 2, and 3. 3 also.
Sorry.
Lord, 1, 2, 3.
1,
4
2,
is a town municipal.
1, 2, 3. Emergent notice to the 4th respondent.
Please, my lords.
6. Serial number 6, Srinivas.
The petitioner challenge the transfer, may pass on the transfer guidelines.
No, no, correct, but it's a promotion.
The promotion, my lord, may
Ah.
just pass on the guidelines for a moment. I'm alleging the violation of one of the,
No, but when you're promoted, how does it operate?
please, my lord, I'll satisfy you. It is a specific, it is not a promotion, it is a person-specific promotion, my lord. It is under a scheme, CAS. And in any case, it is during the academic year, my lord.
No, you just, just only. You serve a Karnataka veterinary animal.
It's
and fisheries.
Vaishali Hegde appears.
Land Council Vaishali Hegde is directed to accept notice for respondent 2 and 3. AGA for first respondent. We'll have it tomorrow.
Please.
Relist tomorrow.
Seven.
Krishna is working in the Muraj
Maybe
schools,
just
my lord. Or they.
You take out notice.
My lord, interim order I'm thinking, my lord.
have to hear.
Similar petitions granted interim order, Annex E, lordship, Annex E. Therefore, there is a threat of relay, lordship.
Who is the answering respondent? Government.
Respondent, not, Siddharth Babu Rao. Second respondent, Christ, lordship.
You bring him. I'll pass over. You bring
Yes,
him.
lordship.
Pass over.
Eight.
For petitioner in this case, my lord. No. Petitioner is a qualified medical social worker, my lord. So renewal, he sought for renewal, my lord.
You take out notice, we'll see.
Yes, my lord.
AGA. Is directed to accept notice for first respondent. Mandya Institute of Medical Sciences. Aurena? Sumana Baliga for 2.
Like, it's covered by judgment.
Huh?
Renewal, renew the other members, my lords, in the same medical institute, my lords. There was 11 vacancy are there, my lords. Vacancy ಇದ್ರೂನು ನಮ್ಮನ್ನ ಕಂಟಿನ್ಯೂ ಮಾಡಕ್ ಬಿಡ್ತಾರೆ. every 6 months ಇದು renewal ಆಗ್ತಾ ಇದೆ.
I'll have it tomorrow, day after tomorrow, you serve Sumana Baliga for the response. AGF first respondent, Sumana Baliga, directed to accept notice, second respondent, list the matter. 6th. In the orders list. Yes.
9.
Petition this matter.
Maybe taken on Monday, my lord.
Like this is a matter, my lord, your lordship kindly recollect, my lord, saying that it is a pension matter where they are the retired employees of the Karnataka Dairy Development Corporation. The matter is also covered by the judgment of the coordinate bench of this honorable court. And in another case, my lord, that now in another case, Krishna Reddy and another, my lord, what had happened was the tribunal has rejected, the repetition was filed, repetition was allowed. They went to, my lord, the state has went to the Supreme Court dismissed it. And recently, my lord, that the order also has been implemented. They are also the Karnataka Dairy Development Corporation employees.
I consult the government and I make a submission on Monday, my lord. I received now the memo.
No, this is different, my lord, because what this one is supporting document to mention saying that, my lord, this has already been implemented. But my only submission is, my lord, they are all more than 70 years, my lord.
Because
I can understand.
Any
KMF has to pay the amount, not the government. KMF, there is no retirement benefits.
but all that is covered is what they're saying.
Matter is covered. My lord, I have also produced the order. My lord, now that is also, I was told that that is also before the government. The another earlier batch has already been, now it has been implemented and the, my lord, that the order has been
No
passed to the
provision
state
for
government.
pension. There was no provision for a pension.
No, correct.
They did it.
Now, if genuinely there is
Second.
something,
Yes.
we can adjourn.
That-
Otherwise, it appears to
No,
be covered.
just now I received the memo
That-
and.
On the
government
last
order. I will
occasion, my lord.
verify it
Okay,
and-
tomorrow, you will have it tomorrow, you
Fine.
just find.
Hmm.
Nale,
Pray-
relist the matter in same
Right.
stage tomorrow.
Tomorrow, my lord, I am having some,
Monday.
Friday, my lord, lordship.
Take
I'm
it
sorry,
on
my lord, tomorrow I
Monday.
am having some.
ಇಲ್ಲ Friday reach ಆಗದ್ ಸುಮ್ನೆ ಡೌಟ್ ಯಾಕಂದ್ರೆ ಮಧ್ಯಾಹ್ನ bench irutte. I'll have it on Monday.
Monday.
Please.
But no further adjournment. It's covered.
Yes, madam.
I heard it
I
also.
have seen.
Monday, in same stage.
Serial number 10, Satish.
Appearing for petitioner, my lord. Matter pertains to compassionate appointment. Your
Yes,
lordships have heard this matter substantially, my lord.
Yes.
I'm requesting for passover, my lord.
Pass over.
Please.
11. 11.
This requires, it's a gray area.
So, my lord,
Now we'll have to, we can't get over the rule which says final order.
no,
That's the position,
no,
unless the rule is struck down. The rule says final order means still final order is passed.
No, that
how
has
it
been
will be?
clarified by the one of the High Court, my lord.
That I'm not in agreement of that because this rule will definitely prevail over the payment of gratuity.
No, that's what the Supreme Court also held recently, my lord. I am placing the judgment.
Put it.
Outside one. My lord, the first judgment,
Let him have a look at it. Let him have a look at it.
Yes, madam.
You have a look at it. What is the point you're making?
no, point is, my lord, page number 14, ink page 14, my lord, Supreme Court has held that the Gratuity Act is overrides the even other enactment, my lord. Even according to the provisions of section 14 of Gratuity Act, where para number, may I read, my lord, page number 14 and para number 18. This court, Vice Singla versus Punjab National Bank, so while considering the issue interest of late payment of gratuity as a retired employee, Punjab National Bank held that payment of a gratuity act will override the Punjab National Bank pension, so while dealing with the issue of a recovery from gratuity under the regulation 46 or withholding a pension under section 46 of the said regulation of the court under section 14 of a gratuity act as held. For 19, it has been, it is a conclusion. In view of the above, it is apparent that provisions of a gratuity have a superiority over all the provisions of a regulation. Here also the same.
Similar issues.
Lord,
Let us
similarly,
see, let us see. Which paragraph? Next judgment?
next judgment, my lord, page number 118, my lord. In another judgment, my lord, similar set of facts has arisen for
Correct, but specifically, and let them have a look with respect to railways.
please, no.
Page 100 and
118, my lord. Ink page, my lord. Para number 8, my lord, page number 120.
this is of the tribunal, order of the tribunal.
Order of the tribunal, my lord.
Let us see.
Tribunal. May I read, my lord, only one paragraph? The appellant, however, argued that Rule 10, my lord, similarly, 10(1)(c) pertains to withholding of a gratuity during the pendency of a department or judicial proceedings. But in his case, judicial proceedings were concluded on 18/5/2018 by so AGMC, and who exonerated him. He contended that a rule does not stipulate withholding so due to the pendency of a criminal appeal. Here also, my lord, since he has already been acquitted in the original criminal proceedings, the applicant asserted that he was entitled to be released. He is withheld of a gratuity from 31/8/2010, along with 12% of the interest.
Let us see. Now you examine, Gautam,
Yes, madam.
whether the railway rules framed under 309
Yes, madam.
would overrule the Payment of Gratuity Act, or the provision under the Gratuity Act would have overriding on the rules, because this will have implication on other matters.
Yes,
also.
my lord.
My lord, the judgment which my learned counsel M.L. Kumar cited before this honorable court, my lord, it says so, my lord.
It says,
The relevant paragraphs, my lord, I think. But he had given SCC, my lord, but
I also
have
produced-
AR, man.
Same, I also.
Same
produced
judgment,
thing.
my lord.
what does it say?
My lord, this page number 12, my lord. Page number 12 is the question which the honorable court framed, my lord.
Page 12.
Page 12, my lord.
Which were the rules in this case?
In this, my lord, the facts was that, my lord,
Which are the rules?
This was
State Bank of India.
yes, my lord.
State Bank of India of service rules.
Yes, my lord.
Okay, which paragraph?
Para 5.1 is the one where the court frames the question, my lord.
Yes.
The question which is posted for consideration before this honorable court is whether it is permissible in law for the appellant employer to withhold payment of amount of gratuity payable to the respondent employee even after his superannuation from service. This was the question which was framed in this case, my lord. There, he had attained superannuation. He was there. A charge sheet was served on him, my lord. A charge memo was served on him, but he retired during the service, my lord. Therefore, he had come. The single judge of the Honorable High Court had held that it was permissible, my lord. Division bench held that it was not permissible in view of Gratuity Act. And the appeal was before the Honorable Supreme Court, my lord. In this context, this question was framed, my lord. My lord, then para 6, my lord.
Yes.
While considering the issues involved in the present appeal, the relevant provisions of CDA rules and Section 4 of Payment of Gratuity Care are required to be referred to and considered, which are as under.
So where is the finding?
Finding, my lord. Para 9, my lord.
Para?
9, my lord.
Yes.
Once it is held that major penalty which includes the dismissal from service can be imposed, even after the employee has attained the age of superannuation and was permitted to retire on attaining the age of superannuation, provided the disciplinary proceedings were initiated while the employee was in service, subsection 6 and section 4 of payment shall be attracted and the amount of gratuity can be withheld till the disciplinary proceedings is concluded. Then, my lord, the honorable court goes on, even otherwise, rule 34.3 of CDA rules permits withholding of gratuity amount during the pendency of the disciplinary proceedings for ordering recovery from gratuity of the whole or part of pecuniary loss caused to the company if have been guilty of offense misconduct as mentioned in subsection 6 of section 4 of Payment of Gratuity Act 1972, or to have caused pecuniary loss to the company for misconduct negligence during his service. It further marks clear that Rule 34.3 for withholding of such a gratuity would be subjected to provision of 7.3 and 7.3A of Payment of Gratuity Act in the event of delayed payment in case of employees fully exonerated. Rule 34.3 of the CDA rules is in consonance with subsection 6 and 4 of Gratuity Act, and there is no consistency between subsection 6 of section 4 and Payment of Gratuity Act and Rule 34.3 of CDA rules. Therefore, section 14 of the Act, which has been relied upon, shall be not applicable, and there is no inconsistency between those two provisions. It is required to be noted that in the present case, the disciplinary proceedings were initiated against the respondent employee for very serious allegation of misconduct, alleging dishonestly causing coal stock shortage amounting to 31.65 crores and thereby causing substantial loss to the employer. Therefore, if such a charge is proved, the punishment of dismissal is given thereon. The provisions of subsection 6 and 4 of the payment would be attracted, and it would be within the discretion of the appellant employer to forfeit the gratuity payable to the. Therefore, the appellant employer has the right to withhold payment of gratuity during the pendency of disciplinary proceedings. This was the finding, my lord, and this later on, my lord, even the one more judge has dissented with the second question framed, my lord, but agreed with the first question framed.
Now, the railway rules prevail over the Gratuity Act.
Yes, my lord, the rules of employment, my lord, would, that's what is the interpretation of the Honorable Supreme Court. my lord.
Let us see, have a look at the other judgments that he has
Yes, my lord.
furnished. Next week, we'll see what is. to be.
Only that which may be in his favor is, my lord, observation para 9.1, my lord. That's what-
Para?
9.1. If that last
Statement
three
of
lines,
Gratuity
my
Act. Could it? 9 point?
my lord, that below 9, my lord.
Yes.
If he is fully exonerated anta adralli.
No, so now one is under the rules.
Yes, my
So
lord.
rules say that till final order is
Yes, my lord,
passed,
final order. That is the problem.
payment of Gratuity Act.
Yes, my lord.
And final order means till order is passed.
Yes, my lord. Or it says, if the departmental inquiry or judicial proceedings is pending.
Or, so
Or
means it either of
both,
them.
either of
Ah.
them, my lord.
So even if he's exonerated,
Yes, my lord.
interpretation of you is even if he's exonerated in the disciplinary inquiry, because it says or judicial proceedings.
Yes, my lord.
So whichever is later, you have to wait till then is your interpretation,
Yes, my lord.
isn't it? Let us see. Let us see, we'll have it next week. Examine that.
That is a one distinguished, my lord. That is a wording has been used as a or.
Or means both.
One, my lord. And second aspect, my lord, even otherwise, my lord, what the Honorable Apex Court has said in the present, the first judgment, my lord, it's overrides, even specific provision has been made, section 14, it overrides the other enactment.
Now that you make your submission also,
Yes.
whether the railway rules
Yes.
under 309,
Yes, my
if presidential assent is given for the rules, examine that point.
yes, my lord.
Overrules the payment of Gratuity Act
Yes, my
or not.
Yes.
That one point you examine.
Yes.
Relist the matter in the same stage on. Because it will have implication on other matters, I don't want to take a hurried decision. Relist the matter on 11. Examine specifically whether the railway pension rules would override the provisions of the Payment of Gratuity Act
Yes.
by virtue of presidential assent, if any, for the rules.
Yes, my lord.
Yes.
12, Vina TN.
Matter pertaining to that,
My lord,
persons who have been retired.
statement of objections are ready, my lord. It is sent for approval to the secretary.
My
It's a
lord,
different,
may-
different department, because animal husbandry department, they take it for approval by the secretary, my lord. Therefore, within tomorrow, I'll file the statement of objection. The case is slightly different from other cases, which they claim for parity. That's what the
Have it on
instructions that is. given.
Friday.
My lord,
Kindly have it on
I-
10th, my
I'll-
lord.
I will
And
finish my submission, my lord, and merit. He is, the fourth time is taking
10th,
time.
10th, your lordship may kindly have it for disposal.
Not disposal in the state, very same stage.
On
10th, my lord. That is on Tuesday.
Relist the matter in the same stage finally on 10th. It's made
I'll
clear
file the statement of
the
objection by
statement of
tomorrow after
objections are
giving the
not
copy.
filed. Court would proceed for orders. Yes, let us see.
Yes, I'll submit the list of judgments. my lord, for the-
ಕೊಡಿ.
ಮೊನ್ನೆನೂ ಕೊಟ್ಟಿದ್ದೇನೆ.
Is on what point?
My lord, there is not left to the discretion of the government. My lord, this is fundamental right. Pensionary benefits and salary, they cannot withheld. One, my lord. Moreover, they are not the new recruits as per the GO regarding applicable to new pension scheme. They have been appointed prior to that.
So there's a tagging,
Yes,
the tagging from the earlier.
yes, retrospective date.
My lord,
And,
my instructions are that the regularized delay.
And my lord, on
2007.
parity, on parity
Yes,
also,
you're
my
asking
lord,
on parity.
I can establish.
And it's a different, slightly different case of the other employees, my lord. That's what the instructions given to me. Therefore, I'll file the detailed statement.
No, but what do you say regarding his earlier stint,
Please.
earlier appointment?
earlier appointments, they have been appointed earlier to these petitioners. That's what it
No,
says.
my lord, may I say?
Dates, dates of their regularization differs from the date of appointment, regularization of these petitioners.
But
And
the
they are
univers-
appointed to the different department, urban development department. Here it's a veterinary department.
No, I am speaking of veterinary only. My lord, government has no say. In fact, the university has no objection. They are the appointing authority. I do not know why the government is dragging like that. I've been retired in the year 2020. They are not paying the pension. And my lord, this is the approach. This shows the apathy of the government. This is the 5th time I'm appearing, my lord.
We list the matter on 10th in the same stage. Yes.
Please, Your Lordship, with regard to appointment of petitioner to the aided post, Your Lordship, last occasion Your Lordship had heard, as per the prerequisite qualification of, as per the notification, I am very eligible for the post.
Yes, yes.
Last occasion, my
But
brother
as per
senior.
the rules, my lord, he is eligible to be appointed, but unfortunately, I did not receive any response from the department.
It's a legal question.
Please.
Now you tell me the facts.
Please, Your
I don't
Lordship.
remember anything.
Please, please. Your Lordship, petitioner was working as an assistant teacher in respond number 6 school, Your Lordship, since 2017.
Petitioner was working as?
Assistant teacher for Urdu language, Your Lordship, in an unaided post since 2017 in respond number 6 school, Your Lordship. I had produced the service certificate at annexure A and B, Your Lordship, and B1.
Annexure?
A, Your Lordship, annexure A, the service certificate issued by the school, wherein they state that since 2017 he was working as Urdu assistant teacher in an unaided post.
Yes.
Since there were 2 vacancies in the school, Your Lordship, for the very respond number 6 school is an aided school, Your Lordship, wherein 2 vacancies were opened for an aided post of Urdu language and arts Urdu, Your Lordship. And the very school for filling up the vacancy and sought necessary permission from the authority and constituted a selection committee headed by the DDPI. And an interview was held, and I produced that interview at annexure C, Your Lordship, page number 18. For Urdu language assistant, Your Lordship, for aided post.
Serial, this is the interview.
Interview, Your Lordship, wherein petitioner had scored highest marks, Your Lordship. The very interview was headed by the DDPI, Your Lordship, respond number 3. And I was selected as an eligible candidate and I scored highest marks, and the same was forwarded for approval.
Serial number?
Serial number, Your Lordship, 3, Your Lordship. Serial number 3. At serial number 3 in column.
Marks,
Yes, Your Lordship, I had scored the highest marks. At page number 20, it is
page 20.
20 and 22, it is visible, Your Lordship. I have scored in the interview along the other candidates. I have scored the highest marks.
Yes.
Yes, in page number 23, it is visible, Your Lordship, at column number 3, at last end, Your Lordship, at last row. BA ಮತ್ತು B.Ed ಸಂದರ್ಶನದಲ್ಲಿ ಪಡೆದ ಒಟ್ಟು ಸರ್ಕಾರಿ ಟೇಕೆವಾಡರು ಅಂಕಗಳು at page number 23. I had scored 71.8.
Yes.
As more than other candidates. Your Lordship, at page number 24, annexure D, that my selection was sent for approval before the second respondent, that is Commissioner, Your Lordship, wherein the Commissioner rejected, saying that I was not eligible for the post. At page number 25, the reasoning has been given, Your Lordship, second paragraph, page number 25.
Yes.
At second paragraph, stating that I had not completed my optional subject in B.Ed.
Just read.
Yeah, please, Your Lordship. Second paragraph, Your Lordship. Merit ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸುವ ಅಂಶಗಳನ್ನು ಅಲ್ ಅಮೀನ್ ಎಜುಕೇಶನ್ ಸೊಸೈಟಿ ಅಲ್ ಅಮೀನ್ ಕ್ಯಾಂಪಸ್ ಹೊಸೂರು ರಸ್ತೆ ಬೆಂಗಳೂರು 27 ಈ ಆಡಳಿತ ಮಂಡಳಿಯ ವತಿಯಿಂದ ನಡೆಯುತ್ತಿರುವ ಅಲ್ ಅಮೀನ್ ಉರ್ದು ಬಾಲಕಿಯರ ಪ್ರೌಢಶಾಲೆ ಶಿರಾ ಟೌನ್ ಮಧುಗಿರಿ ಶಿಕ್ಷಣ ಜಿಲ್ಲೆ ಈ ಶಾಲೆಯ ನೇಮಕ ಮಾಡಿಕೊಂಡಿರುವ ಉಲ್ಲೇಖ 6 ಸರ್ಕಾರದ ಅಧಿಸೂಚನೆಯಲ್ಲಿ ಇರುವಂತ ಸಹ ಶಿಕ್ಷಕರು ಉರ್ದು ಹುದ್ದೆಗೆ ನೇಮಕಾತಿ ಮಾಡಿಕೊಂಡಿರುವ ಶ್ರೀ ಶಫೀವುಲ್ಲಾ ಇವರು B.Ed ಪದವಿಯಲ್ಲಿ ಇಚ್ಛಿಕ ವಿಷಯ ಅಭ್ಯಸಿಸದೇ ಇರುವುದರಿಂದ ಇವರ ನೇಮಕಾತಿಯನ್ನು ಅನುಮೋದಿಸಲು ಅವಕಾಶ ಇಲ್ಲವಾದ್ದರಿಂದ ಇವರ ನೇಮಕಾತಿಯನ್ನು ತಿರಸ್ಕರಿಸಿ ಮತ್ತು ಮರು ನೇಮಕಾತಿ ಮಾಡಲು ತಿಳಿಸಿದೆ. And this further continues with regard to the Urdu language post, your lordship. That is not concerned to us. That's a different post, your lordship. Two vacancies were there in the school.
Yes.
It is certainly this candidate will not be affected with any order, lordship. Please. Further, your lordship, I preferred an appeal before the respond number 1 authority, this secretary, wherein similar observations were made by the respond 1 authority at page number 32, your lordship, impugned order, annexure E.
Page
32.
Yes.
Annexure E, wherein some cyclostically they observed the similar observation by the commissioner, wherein they went on to reject. May I, at page number 33, your lordship, the reasoning given by the at page number 33, para number 4, your lordship.
Yes.
If your lordship permits, may I read or?
Yes.
Please. ವಿಚಾರಣೆ ಪ್ರತಿವಾದಿಗಳು ಹಾಜರಾಗಿರುತ್ತಾರೆ ಹಾಗೂ ಖಂಡಿಕೆಯವರು ಶರಾ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಸದರಿ ಖಂಡಿಕೆಯ ಶರಾದಲ್ಲಿ ವಿವರಗಳನ್ನು ಗಮನಿಸಲಾಗಿದೆ. ಪ್ರತಿವಾದಿ 2ನೇ ನಿರ್ದೇಶಕರು ಶಾಲೆ ಶಿಕ್ಷಣ ಇಲಾಖೆ ಬೆಂಗಳೂರು ಅವರು ಸಲ್ಲಿಸಿರುವ ಆಕ್ಷೇಪಣಾ ಹೇಳಿಕೆಯಲ್ಲಿ ಅರ್ಜಿದಾರರು ಉರ್ದು, ಹಿಸ್ಟರಿ ಅಂಡ್ ಆರ್ಕಿಯಾಲಜಿ ಸೋಷಿಯಲ್ ವಿಷಯದಲ್ಲಿ BA ಪದವಿಯನ್ನು ಕರ್ನಾಟಕ ಯೂನಿವರ್ಸಿಟಿಯಿಂದ ಪಡೆದಿರುತ್ತಾರೆ. CCM ಆಫ್ ಟೀಚಿಂಗ್ ಸ್ಕೂಲ್ ಎಜುಕೇಶನ್ ಇಂಗ್ಲಿಷ್, ಹಿಸ್ಟರಿ ಅಂಡ್ ಸಿವಿಕ್ಸ್ B.Ed ಪದವಿಯನ್ನು ಬೆಂಗಳೂರು ಯೂನಿವರ್ಸಿಟಿಯಿಂದ ಪಡೆದಿರುತ್ತಾರೆ ಮತ್ತು ಉರ್ದು ವಿಷಯದಿಂದ MA ಪದವಿಯನ್ನು ಕುವೆಂಪು ಯೂನಿವರ್ಸಿಟಿ ಪಡೆದಿರುತ್ತಾರೆ. ಸರ್ಕಾರ ಆದೇಶ ಸಂಖ್ಯೆ ED 291 LBP 2015 ದಿನಾಂಕ 29/9/2016 ಸರ್ಕಾರದ ಅಧಿಸೂಚನೆಯಲ್ಲಿ ಇರುವಂತ ಸಹಶಿಕ್ಷಕರು ಉರ್ದು ಹುದ್ದೆಗೆ ನೇಮಕಾತಿ ಮಾಡಿಕೊಂಡಿರುವ ಅರ್ಜಿದಾರರಾದ ಶ್ರೀ ಶಫೀವುಲ್ಲಾ ಅವರು B.Ed ಪದವಿಯಲ್ಲಿ ಬೋಧನಾ ವಿಷಯ ಅಭ್ಯಸಿಸದೇ ಇರುವುದರಿಂದ ಇವರ ನೇಮಕಾತಿ ಅನುಮೋದಿಸಲು ಅವಕಾಶ ಇಲ್ಲವಾದ್ದರಿಂದ ಇವರ ನೇಮಕಾತಿಯನ್ನು ನಿರ್ದೇಶಕರು ಪ್ರೌಢ ಶಿಕ್ಷಣ ಶಾಖೆ ಜ್ಞಾಪನ so and so.
No, what does the rule say now?
Please, at page number 38, your lordship, I have produced the notification.
Yes.
Okay. At row number 3, your lordship. That is language assistant.
Language assistant.
Yes, language assistant in Kannada, English, Urdu and all other languages are involved.
The present post is post
Urdu
of
language.
Language assistant.
Urdu language assistant.
Language assistant.
Yes, language assistant.
So what is the qualification?
Please, at 4, your lordship, may I read the column,
Yes.
row number 4? For language assistant, the very first criteria is, your lordship, must be a holder bachelor degree in arts with the concerned language of one of the optional subject, namely Kannada, English, Urdu, Hindi, Marathi, Telugu, Tamil and Sanskrit. And continues, your lordship, and he must be holder of a degree in education. I fit in very first criteria, your lordship. I have a BA in major in Urdu language, your lordship, and I have a bachelor in education degree.
So just point out those two certificates.
Please, I have produced along with the memo, your lordship. I couldn't produce along with the petition. On 19/11/2024, I filed a memo.
Yes.
Please. At
So-
page number 2 of that memo, your lordship, at document number 1, when I produced the BA certificate,
So this is a bachelor in arts.
bachelor in arts. There is a
And
BA.
one of the optional subjects of
Either Hindi, Urdu, Kannada, what optional subject? Your lordship, he has done first is basic is English and major in language, that is second Urdu
Urdu.
and optional Urdu.
So this fulfills the first
Yeah,
criteria.
he fills it in the first criteria. And he has a B.Ed certificate at page number of my petition, your lordship, 44. Annexure G1, my petition, your lordship. Since the certificates were not available at filing of the petition, I put this 4, your lordship.
This is your B.Ed.
Yeah, he has a B.Ed. They do not specify in the notification whether to have a qualification in B.Ed. They just say that a candidate must have a bachelor in degree education. That's it.
Yes. Now, what is the endorsement to the effect that
Please,
you don't, that you are required to
I am required to have a B.Ed in optional subject. That is not specified in the notification, Your Lordship.
Just read that once again.
Please, endorsement, Your Lordship.
Yes.
Please. At annexure, page number 25, Your Lordship.
Yes.
I'll read it directly. ಶ್ರೀ ಶಫಿವುಲ್ಲಾ ಅವರು B.Ed ಪದವಿಯಲ್ಲಿ ಇಚ್ಛಿಕ ವಿಷಯ ಅಭ್ಯಸಿಸದೆ ಇರುವುದರಿಂದ ಇವರ ನೇಮಕಾತಿಯನ್ನು ಅನುಮೋದಿಸಲು ಅವಕಾಶ ಇರುವುದಿಲ್ಲದರಿಂದ ಇವರ ನೇಮಕಾತಿಯನ್ನು ತಿರಸ್ಕರಿಸಿ.
What is the effect of the endorsement?
My lord, I submitted that it looks like it's an erroneous.
No, they're saying you must have B.Ed.
B.Ed in
B.Ed in
major,
optional
major
subject.
optional subject in Urdu, and that is not the rule. The rule says whatever my learned friend has submitted, it's correct. As
So
per the rule.
so the endorsement is the effect that in B.Ed
Should have
you should
done
have
B.Ed in Urdu language.
B.Ed, that's what it says.
Yes, that's.
But in notification, it does not specify whether B.Ed has to be completed in Urdu teaching methodology or in, it's just plain.
The rule is clear.
The rule says that it's only a major subject in major and language subject in Urdu and
Optional.
supplementary
Yes.
optional, sorry, a B.Ed in and a B.Ed, that's all.
Yes. The petitioner has sought for issuance.
And my learned friend who is appearing for the management also submits that that post is kept vacant.
It is vacant.
The vacant for the, therefore, there's no conflict as on today.
The petitioner sought for setting aside of the order at annexure D whereby the respondent authority has declined to issue
Aid to the
has declined to admit to grant in aid.
granting. Yes.
That's the order.
Yes.
Admit to grant in aid the post of assistant teacher Urdu.
Urdu language.
Petitioner has also challenged the order of the appellate authority at annexure E, which has upheld the order passed at annexure D. Full stop. It is a case of the petitioner that the petitioner was initially working in the unaided post of the institution as an assistant teacher in Urdu. Next, petitioner subsequently took part in the selection process initiated with approval of the government for the post of assistant teacher and had been selected in terms of the selection process as detailed and evaluation made as evident at annexure C.
Yes.
The full stop. It is a further case of the petitioner that a proposal was sent by the institution to the Department of Education for approval for admitting the post to grant in aid. And such proposal, however, has been rejected in terms of the order at annexure D on the ground that the petitioner was not qualified and had not possessed a BA degree with the optional subject of Urdu.
Urdu.
It is the case of the petitioner.
No, my lord, but there's one correction. It's a
B.Ed,
B.Ed degree.
B.Ed Urdu.
B.Ed,
B.Ed
B.Ed
Urdu.
degree.
Bachelor in
degree.
Education Urdu.
Correct, B.Ed degree with
B.Ed
optional subject of Urdu.
Urdu.
in the case of the petitioner, that the qualification mentioned at annexure F, which are the relevant rules, that is the Karnataka Education Department Services, within bracket Department of Public Instructions, close bracket, within bracket Recruitment, Amendment Rules 2016. The post of a language assistant requires the petitioner to hold a bachelor degree in arts with the optional subject of Urdu and must be a holder of degree in education. Petitioner submits that both such requirements are fulfilled. And accordingly, endorsement issued at annexure D and affirmed by the appellate authority by dismissing the appeal of the petitioner required to be set aside. It is not in a dispute that the selection process that was initiated with the government with the approval of the Education Department was as regards to the post of language assistant Urdu, isn't it?
Yes, sir.
Full stop. The order at annexure D rejects the proposal for admitting grant in aid to the post only on the ground that the petitioner did not have a B.Ed degree with optional of Urdu. Full stop. It is to be noticed that in terms of, it is to be noticed that an appeal filed against the said order came to be upheld as per the order at annexure E. Full stop. The relevant rules referred to above stipulate the qualification at CL number 4 as regards language assistant in Urdu as follows. 4, page 38. It is clear from the document filed along with memo dated 19/11/24 that petitioner has done his BA degree with the optional subject of Urdu. The relevant mark sheets are enclosed as also passing certificate. That passing certificate is for all the years.
For all the years.
Huh?
Yes, sir.
Passing certificate. It is clear that the petitioner has done his bachelor in arts with optional subject of Urdu and accordingly fulfills the first of the qualification stipulated in the recruitment rules. Which provides that he is to possess a bachelor degree in arts with one of the optional subjects in Urdu. Full stop. Next. Insofar as qualification at 4B, the petitioner has possesses Bachelor of Education, which is produced at annexure G1. In light of the same, the order at annexure D being contrary to the rules containing eligibility criteria, the order declining to admit the post to grant in aid is set aside, and then you have to proceed for. And who has to take a decision now?
DDPR. No, commissioner has to approve the post, Your Worship.
No, now, order D is passed by whom?
Commissioner, Your Lordship, respond number 2, Your Lordship.
And the respondent number 2 is to pass necessary orders for admitting the post to grant in aid, taking note of the observations made above. Further to passing such orders, consequential orders also to be made. Entirety of the process to be completed within a period of 3 months.
Please.
From the date of receipt of certified copy of the order, 1 paragraph. Learned counsel appearing for the institution submits the post of assistant teacher Urdu remains vacant.
Vacant.
As on date.
Yes, as on date.
And said aspect is taken note of. And the authority while passing orders is to take note of the said position as well and not raise any fresh contention, which have already fresh contention in light of the discussion made above.
Oblige.
Obliged, Your Lordship.
Venkatesh Somareddy, Tom Shekhar.
Appear for the respondent number 3, my lord.
Yes. The present petition has been filed seeking for issuance of a writ of certiorari to set aside the show cause notice dated 9/9/2024, as well as further proceedings pursuant to notice dated 9/9/2024 as per Annexure K. The petitioner has also challenged the order of suspension dated 21/11/2024 at Annexure N. Next, as it was the case of petitioner that in terms of Annexure F, applications were invited from applicants to the post of Managing Director, Karnataka Antibiotics and Pharmaceuticals Limited. And in light of the order of suspension of the petitioner, the said application would not be forwarded to the competent authority. Further relief in the nature of direction to the respondents to forward the petitioner's application is also sought for. This court, by order dated 26/11/2024, had passed an interim order which reads as follows. Extract. Next. IA 2 of 24 has been filed by the respondent number 3, seeking for vacation of the order of stay granted on 26/11/2024. Next. Shri S.N. Murthy, Learned Senior Counsel, appearing on behalf of respondent number 3, has advanced arguments on the said application, seeking vacation of the ex parte interim order granted. Next. Learned Senior Counsel Shri P.P. Hegde has advanced arguments on behalf of the petitioner, opposing the application for vacating stay. Next. It is to be noticed that the Government of India Department of Personal Training / Public Enterprises Selection Board, by virtue of the notification dated 20/10/2024, had invited applications of candidates for the post of Managing Director of Messrs. Karnataka Antibiotics and Pharmaceuticals Limited. The said application was required to be forwarded to reach the PSEB by 15 hours on 4/12/2024. Next, it is the case of the petitioner that he has made out an application, and such application through proper channel was required to be forwarded to PSEB as per the request made on 7/11/2024. He has also made out several reminders to the same effect. It is submitted that, however, in order to scuttle his chances and further the interest of respondent number 2, Miss So and so, the present managing director, it is at her instance who wanted to be appointed in terms of the process which was initiated, that show cause notice dated 9/9/2024 was issued, culminating in an order of suspension of petitioner, vide order dated 21/11/2024. Thus, by virtue of the order of suspension passed at annexure N, in terms of the Office Memorandum of Government of India dated so and so, 24/11/2022, as per stipulation number 6, application of the petitioner could not be forwarded or considered if he is under suspension, which has resulted in his exclusion in the process of consideration for the post of managing director. It was vehemently contended that at the instance of respondent number 2, malified order was passed by respondent number 3, which ought to be stayed. Next, other contentions have been raised even on merits, stating that the allegation made in the show cause notice relates to obtaining approval of the ministry, which approval has subsequently been obtained, that petitioner did not have any role as regards such approval, and it was a lapse on the part of the board itself, that other allegations made relating to spending without following procedure relate to expenditure sanctioned by the managing director. Next, on the other hand, the senior counsel appearing for respondent number 3 would contend that the notification inviting application was only on 28/10/2024, while the show cause notice was issued at an earlier point of time on 9/9/2024. Next, it was contended that the issuance of show cause notice had nothing to do with malified intent to exclude the petitioner, that the show cause notice was issued as regards all the employees, including other employees, namely the Deputy General Manager, Administration and Company Secretary, Deputy General Manager, Finance, Senior Manager, Purchase, and accordingly it could not be contended that the petitioner was singled out. It was further contended that decision taken to fix accountability was by resolution of the Board of Directors, which was again on 9/5/2024, and the board had authorized the managing director to fix the responsibility, pursuant to which, on the basis of inquiry report, resolution was passed by Board of Directors in proceedings on 5/10/2024 to place all officers below the rank of managing director under suspension, pursuant to which order of suspension came to be passed. The senior counsel appearing on behalf of the respondent number 3 has contended that the court cannot enter into merits at this stage, nor sit as an appellate authority as against the exercise of disciplinary power of the employer. Heard both sides. It is to be noticed that one of the primary grounds of attack is that the order of suspension passed was vitiated by malifieds and was at the instance of respondent number 2, who was herself a prospective candidate for the post of managing director. Next, at the outset, it must be noticed that the show cause notice was issued to the petitioner on 9/9/2024 as regards certain irregularities. Simultaneously, on the same day, show cause notices were issued to the other officers, namely Mrs. Supriya Kulkarni, DGM Administration, Mr. Jagdish C, Deputy General Manager, Finance Department, Mr. Kanak Banot, Senior Manager, Purchase Department. It is to be noticed that show cause notice was issued as regards the irregularities relating to approval of KAPL board / ministry as was not obtained as such approval was not obtained before the initiation of the project, comma, that recommendations made for work orders without noticing requirement of approval by higher authorities, comma, as regards not taking approval from competent authority before appointing Messrs. Doshi Consultant Private Limited, etc. After considering the replies, the decision was taken by the Board of Directors on 5/10/2024 that officers below the rank of Managing Director were found prima facie accountable on the basis of report and not to be suspended with direction to the Managing Director to ensure compliance of directions. Next, thus decision to suspend was taken on 5/10/2024 itself, much before the notification inviting applications to the post of Managing Director on 28/10/24. The fact that order of suspension was passed on 21/11/2024, subsequent to notification of 28/10/2024, was an unfortunate coincidence, but cannot be stated to be legal only on such ground. Though various contentions have been raised on merits, it would not be appropriate at this stage to comment on the same, as these are matters to be considered during inquiry. Next, despite learned senior counsel appearing on behalf of the petitioner, pointing out that one of the major contentions relating to non-obtaining governmental approval, which was however obtained on 13/3/2024, nevertheless, the decision of the board to inquire into the lapses relating to Project 7 ACA was made on 9/5/2024, and the board was cognizant of the approval granted, but appeared to still feel that there were lapses. The fact that proceedings were initiated against many employees relating to lapses in the project and taking note of the order of suspension against all of such employees by separate orders of 21/11/2024 passed simultaneously would dispel the notion of targeting of the petitioner. Allegations made are serious, as is evident from the prima facie reading of the show cause notice. If the selection is for the process of Managing Director and board has taken a decision to fix accountability, the fact that Managing Director, being the disciplinary authority, had appended a signature to orders of suspension would not make such orders as orders passed at the instance of the Managing Director, but must be construed to be orders of the board. Accordingly, the allegation of malafide also prima facie does not hold water. In light of the contemplated disciplinary proceedings, order of suspension passed is a decision taken by the employer in its wisdom and cannot be interfered at this stage. The coincidence of invitation of application for the post of Managing Director cannot be a sole ground to stay the order of suspension. The petitioner may have to bear the consequences of the inquiry till he comes clean from the inquiry. It would not be appropriate to stay the order of suspension in light of consequences which the employer may have kept in mind while passing the order of suspension. Though the petitioner may have been excluded from the zone of consideration to the post of Managing Director by virtue of order of suspension, in light of the office memorandum, that may be a consequence of the proceedings initiated pursuant to the show cause notice. No malefides can be read into the order of suspension passed, which could be traced to the show cause notice initiated way back on 9/9/2024, much before the notification of 28/10/24. In light of the discussion above, it would be appropriate to vacate the interim order granted on 26/11/2024. Accordingly, IA number 3 of 2024 stands allowed. In light of the above, no orders are required to be passed on IA number 2 of 2024 seeking direction. Needless to state, the observations made are only for the purpose of disposing of interlocutory application and are open for consideration while passing the order on merits.
Much obliged.
15. Chilparan.
So you take out notice, let us see. I'll pass over, you bring the council.
Is present. Please.
Lord, one request, my lord. There may be not to terminate from the services, but in case in an emergency is required, my lord, to transfer from one place to another place, that may be open, my lord, because this is a school, my lord.
No, that's a different matter. No, that we'll see, that we'll see. Now, we will say not terminate, but you must be ready to go wherever they transfer. So when regular recruitment happens,
Lord.
ಇದರಲ್ಲಿ ಒಂದ್ರಲ್ಲಿ ಸ್ಟೇ, ಇದರಲ್ಲಿ ಒನ್ ಮ್ಯಾಟ್ರಲ್ ಸ್ಟೇ ಕೊಟ್ಟ ಮೇಲೆ
ಹೌದು
35,000 ಜನಕ್ಕೂ ಸ್ಟೇ ಕೊಡ್ಬೇಕು.
ಹೌದು.
ನಾನೇನ್ ಮಾಡ್ತೀನಿ ಆನ್ ಪ್ಯಾರಿಟಿ. They are only
Lord, but one request, my lord, the parity may be given, my lord, but it should not take away the interest of the students, because we have to maintain the
Just 1
result.
minute, let us see. You read page 51. Yes, yes. No, on parity, same order only. How we can pass unless you file vacating in one of the matter, and that is
Obliged.
the ಅದಕ್ಕೆ ಇನ್ನೊಂದ್ಸತಿ ಕಾಂಟ್ರಾಕ್ಚುಯಲ್ ಎಂಪ್ಲಾಯಿನ ತಗೊಳಕ್ಕಿಂತ ಮುಂಚೆ 1000 ಸತಿ ಯೋಚನೆ ಮಾಡಿ.
Lord, what will happen? The school will be.
So there are two sides of the story. One is the serious problem of unemployment, serious problem. And two is you also have to balance, because the recruitment process will take long. Half the time, many a time it's challenged. So the fill up the vacuum, you have to have some ad hoc arrangement. How that is to be balanced is to be seen.
Obliged, my lord.
The petitioner has sought for an interim order to restrain termination or relieving services of the petitioners, or that the petitioner's services must not, and that the petitioner services must not be disturbed by posting teachers through deputation or transfer in place of the petitioners. The counsel for the petitioner relies on the order passed in WP 17267 of 2024, which reads as follows. Next, in light of parity as claimed, there would be an interim order on same terms as passed in WP 17267 of 2024, extracted above, and the respondents are restrained from where is the what is the operational order? Where is the operational order? Which paragraph? According to the interim order, directing the respondents not to displace the petitioners by either transfer or sending on deputation any person to the post held by the petitioners. Full stop. Respondents are at liberty to complete their pleadings and file application for vacating stay. Yes. You have accepted notice in this.
Lord, I accept notice, my lord.
Land Counsel Shri Siddharth Babu Rao is directed to
R2, my lord.
accept notice for
R2.
R2.
Houses.
R1 is
R2. AGA accepts notice for R1. See how much support she has. He'll come everywhere he's there. Our matter ತಗೊಳ್ಳಿ. ಅದಕ್ಕೆ ನಾನು ಅವಾಗ್ಲೇ ನೋಡ್ದೆ, ಬಟ್ his other intention is to support her. ಎಲ್ಲ ಏನಾದ್ರು ಆದ್ರೆ ಅವ್ರಿಗೆ ಹೊಡ್ತಾ ಬೀಳುತ್ತೆ ಅಂತ. So what about this matter?
Lord, this matter also I have seen same in a similar footing, my lord. But they are the teaching faculty, idರಲ್ಲಿ non-teaching faculty.
So there is an interim order passed in other matters. At page 125. 120. What is the order passed?
ಅದರಲ್ಲಿ detail order ಇದೆ, ಇದರಲ್ಲಿ not to relieve ಅಂತ ಅಷ್ಟೇ.
Same or different? Same as previous or different?
Different.
Different.
This interim order is different.
No, but the contention is same.
Maybe connected.
But that is which post? This is staff nurse.
This is non-teaching staff nurse and one FDA is there in this post, in this writ petition. That is all teaching staff, my lord.
Let us see. Lord Counsel for the petitioner has sought for a direction against respondents not to relieve the petitioners from the post held from the present post and not to displace the service of the petitioner from the second respondent's institution. Petitioner relies on order passed in WP 17611 of 2024 and submits that on parity, petitioner may be extended the same interim relief. Order passed in WP 17611 of 2024 reads as follows. In light of the same and taking note of contention of parity, there would be an interim order directing the respondent number
2, my lord.
2 not to relieve the petitioner from duty in the next date of hearing. And Land Counsel Sri Siddharth Babu Rao is directed to accept notice
For R2, my lord.
for R2.
For other response stated.
AGA accepts notice for respondent 1, 3 and 4. Pleadings to be completed and the interim order passed is open for vacation at the instance of the respondent if circumstances are so made out upon filing statement of objection.
Obliged.
They won't dismiss you. Barli.
Orders matter 16. Sir, Manor.
Your Lordship, appearing for respond number 1 and 2, Your Lordship.
Yes. Yes,
Maybe part one.
passed over. Pass over.
Number 17, Srikanth MP.
Now there's a stage. Permission.
By the statement of objection in annexure R, I stated that we are
Annexure
R4, my lord.
Yes,
Yeah, I sent the last parameter.
yes.
ಸದರಿ ಶಾಲಾ ಆಡಳಿತ ಮಂಡಳಿಯವರು ತಮ್ಮ ಆದೇಶವನ್ನು ಪಾಲನೆ ಮಾಡದೇ ಇರುವುದರಿಂದ ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ 20 ಆದೇಶದಂತೆ ಯಾವುದೇ ಆಡಳಿತ ಮಂಡಳಿಯವರು ಹೆಚ್ಚುವರಿ ಶಿಕ್ಷಕರನ್ನು ಕರ್ತವ್ಯಕ್ಕೆ ತೆಗೆದುಕೊಳ್ಳಲು ನಿರಾಕರಿಸಿದಲ್ಲಿ ಅಂತಹ ಹುದ್ದೆಯನ್ನು ಶಾಶ್ವತ ಅನುದಾನ ರಹಿತ ಹುದ್ದೆ ಎಂದು ಘೋಷಿಸಲಾಗಿರುವುದೆಂದು ಆದೇಶಿಸಿದೆ. We have sent the principal my lord, he has not accepted that person. ಉಲ್ಲೇಖದ ಆದೇಶದ ಕ್ರಮ ವಹಿಸಿ ಅನಾವಶ್ಯಕತೆ ಈ ಕಚೇರಿಗೆ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸಿದೆ. ಶ್ರೀ ವಿಶ್ವಭಾರತಿ ಶಾಲೆಯ ಮೇಲ್ಕೋಟೆ
No, but now,
ಶಾಲೆಯಲ್ಲಿ ಈ ನಿಯಮಾನುಸಾರ.
Allah, but now they rely on the observations made
Yes, in the
in WP 33101.
It is there.
Huh? 33101 page.
Page of what? 110, it is there.
11.
I get the instruction, my lord.
Allah,
It is clear.
Allah, judgment is there. Just read that paragraph once again.
Yes, my lord. Why not 14?
Code is of the considered opinion, the thousands of 68 of the act and the rules of opinion are equal to the down to make it more effective, workable and ensure the attainment of the objective. Provisions contained in section 88 of the act include in the matter of locating, transferring the future employee from one private agency institution to another shall be done only with the consent of the government person. What I am not saying of that. Without asking him what someone else is going to my institution. Will not take him.
No, but can you say that I will never take? This is a minority institution. No, but can you say you will never take anybody? Where will you consent? Now, in case of excess staff, suppose, or let's assume that the student, I'm just asking, let's assume in an aided institution, one of the strength of the students falls down, and then they have to deploy that person to some other college having a post. Then how they can put it into, how can they exercise such power?
From other institutions for different reasons. Not in some areas, not they not be having mathematics teacher, arts teacher, they not be having such teachers will be taken by the institution. But
No, but now on what ground you are seeking to say that you don't want to admit, you are already, you already have. Now, now what do you say? Now we don't have,
Needed.
now we don't have much discretion in the matter in light of the observation of the coordinate bench. I can only say the endorsement is set aside and you have to reconsider it in light of such observation. That's it. Because you have not challenged that order. As long as you don't challenge that order, then there's a problem for you. The petitioner. This order has attained finality, isn't it? The petitioner. But according to me, it may be a little difficult.
Example, when you are considering not the university rules, where there is specific provision is made.
What is?
Was also cited below.
This has been deferred with, no? Para? No, just point out the reference. Let us see to this order what the court observes. Para?
78.
Yes.
The decisions that are from yeah, here, rule 52 of the 2006 code, not specifically considered. The last is the German code of code. But here it is a high school. But 2006 rule is the institution which was
No, there is no rule, is it, in the present case for a
There-
deployment of excess staff?
In statement of objection, I mentioned that.
269.
So what do you say now?
That is,
And set it aside and leave it.
we
Because now,
declare it a non-needed
huh?
post. We declare it as non-needed post, we are not granting it. Because they are not accepting our proposal. Time and again.
Because the unneeded post, but she will be. She is about to attain what.
Correct, but then there's something that you have to sort it out with the government.
Rule 6.19 rules was considered. That decision which I cited to a lodger. is on the premise that rule 23 melodies of 2006 rule, which is university rule. But condition not has no application, but for state.
What do you say? You have a look at this order. He says that that this however applies only to pre-university.
Pre-university, no. Yes. ma'am.
No, but no institution will accept. It's a difficult.
I'll take that. Because there is lots of melodies teachers in those areas. Scholarships appreciate melodies in.
Anyhow, I won't enter into that. But then there's no, the government will not be able to send excess staff anywhere if the private institutions. No, let us see. Anyhow, I can't enter into that. The petitioner has challenged has called in question correctness of the order passed. No, this is a circular, is it?
Circular.
8/6/2018.
Then the post will be treated as permanent pay annuity. That is what this is.
No, but then no, sir, this circular is not modified pursuant to the coordinate bench. Then you have to at least seek for some contempt or some direction for looking into it. Then when there's a circular, how do you get over this?
That's not for partial of that clause.
No, that I can't. Then that requires hearing. I don't want to quash the circular. Without quashing the circular, if I send it. No, let us see. This requires hearing. Let it come up in B group. No, it has implications otherwise. I am also not convinced. There has to be some way out of it. You sit with the government and give some proposal, let us see. But I can't strike down the circular. Court only said it's to be read down, but it has not disturbed that power.
That's it.
Correct. So now, if they demonstrate that this person is in excess, now the institution must accept. Let us see. We'll hear it. Not is it. No, let us see. Have a look at this order and come back.
Yes.
He's saying that this order, however, is distinguishable in WP 5491. 5491 of 2012 on the ground that this order relates to pre-university and the present is not that case. Because here it says you are obliged to admit those in excess. Have a look at it and you come back. No, in all fairness, you have submitted, but I have not yet decided. Let them take a call on that. Let us see. Maybe, but we can't quash a circular only because of one case. It has other implications.
Supreme Court said, but what teacher can request service if it is government institution, even if it is a native institution. There are some other institution, the other school, the DMA is case. Not income from the 2002 16 is issued in AMA by Honorable Proceedings. That this is not very like this. But this won't affect the teachers also. Those who are identified as excess in some other institute, they're not being in a position to get any further employment, maybe for different reasons, not including
The selection was done, you have to send a proposal, is it, or selection is already done?
saying that we did not take the time. So whereas the excess teachers are concerned, over sent over institution, let it take, there is no question about, cannot say that we can choose, nothing like. That's the reason that some who could say, there has to be consent.
Look into that and you
Look
come
at-
back. Realist
After
the
2 weeks,
matter. You ask the AG also what is to be done,
Yes, my lord.
because this is an issue that is going to come up repeatedly. Try to find some solution because of the order of the coordinate bench.
Yes, my.
Realist the matter. When do you want it?
After 2 weeks, after vacation.
In the week commencing from 13th of January. Yes. In the same stage.
18,
He is happy. He feels it may be a better bench.
18,
No, just in the light. No, absolutely. There's nothing wrong. Yes.
My lords, they are not covered by judgment. They were the contract basis. They were appointed on the contract basis. We have to put forth some of the contentions to prove that they were not the employees they're claiming to be. They were the contract basis employees. So
Have you filed your statement?
we have to file the statement of objections. Given time, we'll file the statement of
You
objections.
file it. Paragraph, page. Yes.
Before that, you was at para 43 for a moment. Para 43. Page 209. We shall now. We shall now venture to convert it.
Yes.
if it does not any act of
Now come to para 60. No, correct, but let them take their stand in writing. We'll notice this order. Let them also take a stand and point out if in fact your assertion that there's same work.
Indeed.
So now what does it finally say? Do they say that you are entitled to pay the basic of a regular employer? Yes. Yes. Correct. Correct. Now you just take me to the act. You're seeking welfare act. No, correct. Now you're seeking benefit of extension of protection as under the welfare act, is it no? So the minimum means the basic pay of a regular What is the work?
garbage vehicles.
Let us see, you take a stand in writing.
We have different stand as to similar post-similar responsibilities that will be put forth in the statement of objections, my lords. Similarly.
Whether driver. We have documents to show that whenever the regular driver is on leave, if contractual driver perform the work of the regular driver. One thing. Therefore, we want to report on death of an employee, they have been shown regularly. Apart from that, not even a single direct utility. Certification required is the service person. All of these are covered.
The counsel for the petitioner submits that the entitlement of equal pay for equal work is on the premise of right against exploitation. Full stop. Reliance is placed on the judgment of the apex court in state of Punjab and others versus Jagjit Singh and others, 2017, 1 SCC, page 148. In particularly as regards the observations made at paragraph 57 onwards. Full stop. It is submitted that by virtue of observations made at para 60 in law, if the work being performed is similar, petitioners would be entitled to claim wages on par with minimum of pay scale of regularly engaged employees holding the same post. Full stop. Counsel for the petitioner further submits that the work of the drivers being performed by the petitioner are identical to the work of regularly recruited drivers. Full stop. For the say of the respondent, who, while filing the statement of objections, is to specifically advert to the aspects raised in the petition, as well as the legal position emanating from the judgment in the case of Jagjit Singh and others. Full stop. The respondent to also take a specific stand with respect to the assertion of the petitioner regarding similarity of work of the petitioners with that of regularly recruited drivers. Statement of objections to be filed within 10 days.
2 weeks, after 2 weeks, my lords.
2 weeks.
We have to see
This is
some
the
of the
matter
instructions.
in the week commencing from 13th. Yes.
19, Ravindranath K.
In that week,
Appear for the respondent.
yes.
19,
Seal number
67.
30. Then 67 and 68, as well as 71. ಆ ನಂಬರ್ಸ್ ಬೋರ್ಡ್ ಅಲ್ಲಿ ಆಗ್ತದೆ ಆ ಬೋರ್ಡ್ ಅಲ್ಲಿ ಆ ನಂಬರ್ಸ್ ಫೀಡ್ ಮಾಡಿ. Now all these are similar.
please, my lord.
Yes.
Seal number 30 and 71 appear to the respondents.
Huh.
They have not yet received our complete instructions and sealing cannot complete. That is the
ಇದು 2:30 ತಗೊಂಬೋದಾ ಮಂಜುನಾಥ್? ಬೇಗ ಆಗಿಲ್ಲ. We'll take it up at 2:30 so that the other council, no, you appear in the others.
I appear for the respondent in 30 and 71.
30 and 71. 67, 68,
I appear for 67, 68.
you appear.
Please.
So all the councils are there.
All the
Huh.
councils are there.
Huh.
What my learned friend is submitting is that I represent MESCOM,
Huh.
he represents BESCOM,
Hmm.
and he's
We have not yet completed.
No, that's okay, but you were mentioning the reason for consolidation is you
the
wanted
common order of the inquiry officer
Huh.
was passed an order. Although he has passed an individual order, the subject matter and the contents of that order similar.
No, you were saying that the government also requires to take a
Please, my
stand.
lord, what has happened is the inquiry officer has passed an order
Hmm.
which does not settle the matter as far as the employers are concerned. I am still unable to decide whether the mass card produced by the candidate is fake or genuine. That is the core issue.
No, now, just 1 minute. Now, all are similar posts, is it?
Please,
Post of
lineman,
assistant
assistant lineman.
lineman. Okay, so the qualification is ITI. Now,
A mass card which is been granted by the Department of Employment and Training.
Huh.
All of them have produced a mass card
correct. Now,
granted by the Department of Employment
all
and
the
Training.
ITS come within the control of the government. Now, government, the only way subject to both sides agreeing. Hmm.
Also, cross-examine. Not various, not the thing not which has to come out. That not whatever the marks that were issued. Is not it is issued by the not
Specifically state. Then there ends the matter.
No, my lord, it is not so. I can point out.
Just
Let
in
them-
one of the cases, you point out the
Please,
stand taken by the
Please kindly come to.
No,
this-
but if you don't have any objection, if you don't have, because you are the persons who will be affected. If the government were to verify and make a statement in all the matters by the authority, competent authority in the ITI college, as to whether the document that is forwarded is genuine or not, there ends the matter, even without entering into a discussion. No, I'm saying inquiry is not required. What I'm saying,
One
now,
minute.
without entering into the correctness of the inquiry, if the government would again say that the certificates given are genuine, the employer may be ready to accept it.
Please. Now, there is another issue here, my lord.
Suppose, no, just one minute, just see. Of course, I'm not going to decide today. I'm saying tentatively, what your colleague was pointing out, that they don't have any personal interest in the matter as long as the person is qualified. So if the government were to take a stand that the certificates are genuine upon instructions and file an affidavit of the concerned, there ends the matter.
There ends the matter.
There ends the matter. Suppose the principal or whoever we can direct that person to file an affidavit.
Correct.
And to state after inspecting the register regarding these documents, there ends the matter. Why enter into the correctness and adjudication
Please.
of the inquiry, etc.? Because now if you enter into that, again remand, there's no end to it.
There is
The
no-
only way of putting a full stop is the only point is whether it's qualified or not, whether the certificate is genuine or not. Let an affidavit be filed by a responsible officer or who's a custodian, and he states verified, all are genuine or otherwise. There ends the matter.
In fact,
My,
in fact, he can use.
Huh. That we can't enter into this process.
That is the reason I am mentioning, my lord. So therefore, my lord, my submission is that the definition of genuineness itself is under scrutiny here. The department feels that merely because there was a procedural lapse, if they say that the mass card is not genuine, that is not the way I understand. When they say the mass card is not genuine, I mean to say that it is not a genuine mass card. Whereas the department appears to say that a procedural formality was not followed, therefore the mass card is not genuine.
That may not be, that we may not be in a position.
They have to clarify that. They have to clarify, because ultimately it is the department which is the custodian of the mass card, which has issued a mass card. Now they have to categorically say that merely because there was a lapse in procedure, can they say that the mass card is not genuine?
No, now we can't enter into that approval, etc. Now, whether you have issued the certificate, there ends the matter.
There ends the matter.
It's otherwise what happens, you are now entering into the whole process of approval of the college from that. We can't enter into that. Prima facie, whether the PU board has issued the certificate, there ends the matter.
Yeah.
It should not be that it is a forged.
Exactly. The
that is the point.
genuineness does not mean forced.
Correct.
Non-genuineness does not mean forced.
Correct.
But I understand it as forced, because as an employer, when I get a certificate saying that your mass card is not genuine, that is the only conclusion that I can draw.
That they have to clarify.
That they have to clarify.
already a mass card verification.
Good. Approval for what? Then they should not have issued the certificate. Then what we can do, we'll have a look at the inquiry
Report,
reports
please.
and then take a decision, because simply asking them, there's no end. They will not come up. It will go like this. Another 100 years, it will go on. We will see what was the observation made by the division bench, what was the finding by the inquiry officer, and then decide.
Please. And also in the meanwhile, a coordinate bench has already passed an order where it says that there is no need to again refer the matter to the inquiry officer. And the management has to take a decision accordingly. Now, I have to take a decision accordingly, assuming that the mass card is fake. I cannot take the responsibility or infer that the mass card is not fake.
No, but what is the finding of the inquiry officer? Then there ends the matter.
Let them point it out, my lord. It is not so. I will take your lordship through the. I will take your lordship through
Then
the
all of
inquiry
you
report.
get ready. All of you get ready.
Please, please, ma'am.
We'll club all these matters. We'll club all these matters.
Please, please.
Seal number 30, 67, 68 and 71 are to be taken up together. Huh. So you're not being paid.
They are being paid.
Okay. So now you have access to all the inquiry documents, isn't it? It's a common or separate?
It is large. It is largely common, but individually, for example, certain inquiry reports are elaborate. The subsequent inquiry reports are not as elaborate as the previous one, but the subject matter is the same. Because they have examined the same authority. There can't be any other authority.
Okay, then we'll fix a date.
Please.
When do you want?
Not all the reports.
But anyhow, I've clubbed it. I can only fix an early date after vacation. No, correct. But then they also have to be ready. You are the only respondents, 2 advocates, or others are there.
For BESCOM, we appear.
In all.
MESCOM, I appear. BESCOM,
so you require some time. Okay, so it's your call, either before or after, however you say.
Not able to collect all. There are differences in the inquiry report. The allegations are not similar.
Okay, so what we could do, though we may club it, in order to ensure a uniformity in approach, we will take it one by one only. Each case. Suppose we take one inquiry, and then it will be followed by the others. So there's a uniformity in approach.
It is also possible.
Can't be done by a blanket order.
Correct.
It's not possible
Please,
at all. It has to be done case by case. Now, since we have clubbed it, you complete your instructions, then it will be taken case by case.
Please, my lord. In fact, it is also possible that in a rare case, there could be genuinely a fake mass card.
Possible.
It is possible.
Possible.
We cannot rule that out.
Yes.
So therefore, we need to go into the root of this matter, and they have to individually, every mass card, they have to certify whether it is genuine or not genuine. It is not a general statement that they cannot make.
Now we'll have to only look into, there's no point in revisiting the government, but we look into each inquiry report. And
Please.
then on that basis, see
Please,
what.
please.
Now, if at all, government was of the view that you have got excess in admission, etc., they would have cancelled it. Not having done, we'll have to accept it as it is. Whether it's forged or not may be the only point of inquiry. We may, but anyhow, let's see. But we'll. Correct. Now, so far as that, there's no dispute. Suppose it's forged. Then it's for them to make out a case that the finding of the inquiry officer is perverse. Suppose they were to say, no, that finding is. Then that would, we have to remove those batch. But So at least those who are caught in the crossfire will have to decide.
Exactly.
We've removed. So so then you will have to show either. So okay, you tell us when you want, we'll fix a date. When do you want it?
Can it be,
This is the matter.
it be taken as part heard, ma'am?
No. This is the matter. No, then if it's possible before, I
Because,
leave it to you, but I
What has
can't,
happened is, my lord, since there are a large number of cases, many petitioners have come with a specific request which has been granted by this honorable court. And the issue, as it gets delayed more and more, the more complications are arising. That's the only issue, my lord, nothing else.
You want to take a chance, last week I'll put it, but not sure. No, but we may not have time to go into, let's see if the roster gets repeated. This is the matter in the week commencing from 6th. Let's see if the thing I will take.
Please.
Interim orders in operation are extended till the next date. These are the only matters.
These are,
No.
I'm handling 3 matters.
Yes.
Because he is a champion, he's handling some 60 to 80 matters.
No, all these matters are in this batch, isn't it? Yes.
We will,
You have it clubbed there.
we will have it clubbed. We will have
So
it clubbed.
whatever happens, let it come before the same.
Please.
Yes.
Oblige.
20, Nandareddy PN, Chandrachud.
Lord. Maybe a small accommodation, my lord, the instructions are forwarded to my office. I just need to prepare it and send it back to their vetting. But it's a matter wherein that
It's also covered by the
diploma
decision of this
certificate.
honorable court. Diploma obtained from distance education institution, university is not applicable. The identical matters ಬೇರೆಯವರು ಕೊಟ್ಟಿದ್ದಾರೆ.
Anyhow, you complete your instruction. Statement of objections to be filed by the next date. List the matter in the week commencing from.
30th of January.
Yes.
21,
Office objection may be overruled.
What is the office objection?
Last time it was, I think it was overruled.
There are some. Yes.
Very well.
21,
This case I pay for petitioner, my lord, sir.
Yes.
The case last occasion, my lord, sir. Writ of mandamus, my lord. Annexure K, my lord, my lord.
Yes.
Page number 48, my lord.
Last time, why it was adjourned?
It was the
Your lordships had directed me to file the compliance affidavit filed by
compliance
the
affidavit.
state in the contempt proceedings.
Good.
That compliance affidavit was filed. What had happened in this case, my lord, I have filed writ of mandamus, there was a direction, conditional, I have filed contempt petition, my lord, sir. There was a specific direction by the portal number 1 to give a positive response. In view of the fact that there is no sitting in portal number 1, the matter has been listed before portal number 2. There, the learned counsel appeared for the.
No, you just take me through the facts.
Please,
Now, this was the only document that we wanted.
Yes, my lords.
Let us-
annexure M, my lord, your lordship kindly have a look at.
Annexure?
M, my lord.
Yes.
Operative portion is at annexure 55, page number 55.
Yes.
Learned counsel appearing for the, both the parties who submit that the issue involved in this fiction is covered by the judgment of learned division bench of this court in 39,634 of 2004 and connected matters. In the light of the aforesaid submissions, in terms of the judgment passed by the learned division bench of this court cited supra, these writ petitions are allowed. These, the respondent state to comply with the order within 6 months from date of receipt of this order.
So let us have it, look at 39,634.
Please. Even prior to that, 2003, there was a conditional order, my lords, directed the respondent to pay compensation. Page number 138 minutes. before KAT, in page number 138, it was directed that 12% of interest is to be paid to the petitioner from the date of order till the date of realization. And subsequently in the writ petition before division bench of this honorable court, in page number 340 minutes,
Page number,
340, last page, number, last but one. The order of the KAT has been upheld and directed the respondent to pay the interest on pension.
no, this is the observation, the division bench.
Yes, ma'am.
That is WP 3963.
39.
It starts at page,
Start at 148 minutes. 142 and the operative portion is at 340 minutes. In 340, the
Just
order,
yes, read.
it is upheld. The order of the KAT has been upheld and the respondents are directed to pay the interest on pension from the date of order till the date of realization.
Just read that operative portion.
That I have highlighted.
Ah.
I'm sorry, I'm not having copy.
Within 6 months.
House. And subsequently, I have filed writ petition in the year 11,510 of 2000.
Now, you were a party in this or no?
Yes, Millets.
You were
We
party
are all parties in this.
in this
All the three petitions before this honorable court are parties to the
order in the division bench.
Yes.
Now, till date, they have not settled.
KAT was not settled. Division bench was directed. Subsequently, I filed writ petition before this honorable court 2018. There was a condition order to pay, but I have filed contempt. Contempt petition was also dropped for the reason that I had told. Your Lordship, kind of look at the division bench has observed annexure N millets in page number 56 millets. The operative portion is at 59 millets, considering the last parameters.
Yes.
Considering the facts of that the complainants before this honorable court are in their advanced age and their age ranging from 73 to 82. Even today it is 85 minutes. We expect that respondents number 5 would file positive response. After this, the arguments were heard. The division bench directed me to produce memo of calculations. I have produced the same before the court. Subsequently, when the no session was there in the portal number 1, the matter was listed before portal number 2. The AGA has made submission, compliance has been done.
What is the
The
complaint?
matter was dropped.
What is the compliance affidavit now? They've given you a copy compliance affidavit.
Compliance affidavit.
Copy ಕೊಟ್ಟಿದ್ದಾರಾ?
Copy.
Now just
I filed objections for that also.
Yes, sir.
Given.
no correct. Now what is the compliance now?
My lords, on page, in page 5 of the memo filed now, my lords, we extract the operative portion at para 3, the affidavit filed of the judgment of the division bench, my lords, in 39634 of 2024. The ex-Shanbogs are entitled to pension under the government order dated so and so. So state is directed to fix and pay the pension in terms of the government order, as well as the impugned order passed by the Karnataka Administrative Tribunal within 6 months from the date of receipt of the copy. Till the pension is fixed in terms of the government order, to pay honorarium, to pay ex gratia, amount paid as so-and-so shall be deducted from out of the arrears of the pension payable according to rules, and only balance amount of arrears of pension is payable to the Shanbogs. Prior to this, my lords, I don't have a copy of the judgment, but payment of pension is discussed in detail, my lords. The honorable court.
No, but you're required to take a stand as regards payment of
Interest is
pension-
not referred to.
payment of pension in terms of government order dated 28/11/79.
Yes, my lords. We say we've paid. Interest is not part of that government order. We were asked to pay in terms of the government order.
No, the division bench has said interest.
It-
Division bench has said interest.
It is
My
stated.
lords,
Huh?
Even the endorsement issued to Encobrao has been withdrawn by the government, my lord, during the pendency. The division bench has shown displeasure for the reason that you are not entitled to, they have issued endorsement, my lord.
At para 57 of the order of the division bench, those. You are a party, isn't it?
We are parties, my lord. All the three petitioner peoples are parties. This is the fifth round litigation, my lord. 2003, we have filed interest on pension. 2010, division bench was ordered. 2018, I only appeared, writ petition was disposed of, my lord. Subsequently, I have filed a contempt petition before this court. Due to consensus addendum, the matter has been dropped for the reason that compliance has been done. Even if it is matter is been listed before the quotal number 1, the matter would have been decided. Unfortunately, it was posted before the quotal number 2. On that day, I was not present before the court. Therefore, compliance has been done. The contempt petition filed. Hence, I have filed this.
Now you are
Again, repeating the
no, you're correct. Now you are seeking for
writ of mandamus directing the respondents to pay interest on pension, my lord, from
only on
date
the
of
interest component.
interest.
Now, in light of the division bench order, you have to pay interest.
Oh,
In light of the division bench order, and their parties. In
Yes,
you are at serial number. That I'll, so if that is so, then you are bound by the division bench order. So we'll have to merely dispose it of, directing necessary orders to be passed regarding release of interest in terms of the division bench order.
Please.
We be permitted a short accommodation to look at the KT order, my lord.
To?
State order is there.
No, correct. Now division bench has upheld it. Division bench has directed payment of interest.
Oh,
KT order.
Interest was sought for, that's all, my lord. If that is so, then I do not have it.
340 minutes. In page number 340, operative portion is there.
The KT order.
KT order is at in page number 138 minutes. Operative portion is at 138. The respondents are directed to pay 12% interest from the date of order till date of realization.
That is also there.
My lord,
Also there.
all that I would submit, my lord, I understand your lordships are saying this. The honorable division bench in fact discusses the issue of pension in so far as Shanbogs are concerned. And before the operative portion, it says that we'll have to sit across the table and negotiate and arrive at a pension that has to be payable. In so far as interest, it is not discussed would be my submission.
No, it is
No, but in the correct in the operative portion,
Yes.
there is a direction of interest and it upholds the KT order,
Yes.
which again
That-
provides for interest.
That I cannot dispute. May I only present one circular that has been passed? My lords may take note of it, record my objections and pass orders.
That circular was overruled.
It was?
That circular was overruled. The circular what they have issued, division bench, before division bench,
It's referred to.
they have, this circular was produced, my lord. Before the division bench has made displeasure and directed them to withdraw this thing. They have withdrawn this thing.
I apologize.
And subsequently, they directed me to produce the memo of calculations. I have produced all the 3 memo of calculations from the date of order till the date of realization.
No, but what about this circular?
This is of the year 2020.
2022, this circular was produced before the division bench. The division bench has endorsement was issued on the basis of this circular minutes. That the division bench has shown displeasure and stated that to withdraw the this endorsement issued to petitioner before the honorable court, as they are entitled for interest on pension. This is not applicable to the in the proceedings, in the order sheet, it is there, my lords. May I
No,
make this,
no, the one solution we can give, in case you are agreeable,
please?
then you can sit across with them and work out some amicable arrangement.
Right.
I'll fix a date. You ask, you have a
18%
joint,
in-
huh?
80%.
ಅಲ್ಲ ಏನಾಗಿದೆ ವಾಟ್ ಇನ್ ದಟ್ ಮೆಲಾಟ್ಸ್ ಇನ್ ದಟ್ ದೇರ್ ವಾಸ್ ಎ ಆರ್ಡರ್ ದಟ್ 18% 12% ಮಾಡಿ ಅಂತ there was one order.
No,
20 in
correct.
the year 2023.
What I'm saying that if you are ready and you are ready to work out a amicable settlement, then you sit with them, call them and tell them.
Even when I filed contempt, all they have not done.
ಇಲ್ಲಿ ಇವಾಗ ಮಾಡ್ತಾರೆ ಇದು. Now in case you want to save something, only ways to call them, tell them I'm going to pay you so much. You give some concession in terms of interest. They will accept. They don't want to spend time in court. But you will have to make up your mind. Unless you at your highest level, you call them and sit and work out a settlement, it won't be solved.
But maybe
Because if
disposed of on the same direction, maybe disposed of minutes. We will appear before the and disposed of in a conditional. with a
You tell me
conditional-
now, in case you're going to take some personal interest, have them called with your secretary, sit across and do, I'll have it 10 days, but on that date I'll pass an order. By then you try to work out a settlement well in.
Permit to communicate with them.
Taking note that prima facie state is to,
Even my lord, sir, I will make submission. AAT, there was a conditional order. Division bench, there was a conditional order. If that has not been complied, subsequently, if some circular was issued, that is not binding.
we agree with you. In Bagidire, state is required to comply with the direction prima facie filed. Having perused the order in WP 39634 of 2004, relief sought for by the petitioner is a matter that requires compliance. full stop. Though AGA would rely on the circular of 4/2/2022. However, an order of the court would require proper adherence by the state. Full stop. Next, without entering into further merits, as counsel for the the petitioner submits that the request has been pending since 2010.
2003, my lord.
2003. The state is to address the grievances of the petitioner by calling for a joint meeting of the petitioners and the, who do we say?
And the difficulty is that, my lord,
Revenue Secretary. Huh?
the petitioner is in Ballari and ಈಗ ಇರೋದು
To call-
retirement, my lord.
To call, to convene a meeting with the counsel for the petitioner.
Please.
As it is noticed that the petitioners are senior citizens and the respondents to be represented by
My lords,
Revenue Secretary,
revenues.
by Revenue Secretary. Joint meeting to try and work out an amicable resolution of the dispute, which would also be in the interest of the respondent state. Full stop. Counsel for the petitioner submits that he would also be flexible in trying to reach to an amicable settlement if reasonable offer is made by the state. Full stop. Such meeting to be convened during the next week.
Next week, my lords may not fix the time.
Huh?
Subject to the availability of the secretary.
Whatever you make arrangement, your Revenue Secretary is proactive, and I'm sure he'll realize that in such matters, it's better to settle it. Relist the matter on last week.
14.
14th, 15th, 16th. You
Please.
try, otherwise it will go before another bench. And now, as it is, you are requested to pay it. You
Yes.
can't get over by mere reliance on the circular.
Yes, ma'am.
So if it goes deeper, then you have no case. Better you settle with them.
I communicate.
Would it be
Copy of the
13th?
order to be furnished to the AGA.
Would it be 13th, my lords?
13th. 13th.
13th.
Yes.
22, location.
You can arrange for a video conference meeting also at least. In case he is not available, etc. You arrange for a video conference meeting. You must be there. He must be there. You can both sit and then you ask him to connect to video conference and you settle it. See, even any small concession in interest is a boon to you. You can't get over the court order by the circular. Yes.
I appear for the petitioner, Your Honor. My lords, it's matter relating to recruitment for the post of junior engineer electrical to KPTCL, my lords. My lords, the question before my lords is that there was a mistake committed by the petitioner in the recruitment application, my lords. The question was whether she has studied Kannada language in SSLC or not. She says inadvertently no. This is not a fatal error, my lord, because if she had not, she should have taken Kannada, compulsory Kannada examination, which she did not as she has studied. But her candidature had to be rejected before giving the aptitude test. The respondents don't cancel her candidature on that mistake. Later, she writes the examination. In the result, they show her as non-eligible candidate, and in the final list, 50 people who secured less marks than the petitioner were given the post.
Yes,
My lord,
who appears for the employer?
Discretion.
Huh?
Today, my lord, the matter is listed. What happened, my lord may peruse order sheet of 18/7/2024. The coordinate bench of this honorable court had framed the question, my lord. What had happened, my lord, while hearing the matter at the preliminary stage, my lord, the respondents objected for an interim order, saying that final list has already been drawn. The necessary parties have not been made parties in the writ petition, hence interim order need not be granted.
No,
Anyway,
no, we understand, but now it requires a judicial order only. So let us see, we'll give a date. We'll make it clear that the court would mold really appropriate relief.
Correct, my lord. What is before my lords is that that interlocutory application that I have filed for impleading those candidates. What my submission is, my lord, out of 486 posts, they have only appointed 461 people. They still have vacancy, and I am in my humble submission, I am eligible for the posting. I'll convince my lords. If they can come up with a proposal, my lord, that as they have not filled all the vacancies.
Yes, what do you say?
6/11/2024, I have served on.
I think Kodi, we'll have it next week.
I will.
We'll have it next week. Let us see. Relist the matter on 13th.
Much obliged.
23.
Please, my lord, appear for the petitioners, your lordship.
My lord, I appear for respondent number 4. My
Yes, yes.
absence before, my presence before my lord in person may be excused. ಅದು ನೆನ್ನೆ ಮಧ್ಯಾಹ್ನ ಮಳೆಯಲ್ಲಿ ನೆನ್ಬಿಟ್ಟು ತುಂಬಾ ಕೋಲ್ಡ್ ಆಗೋಯ್ತು ಸರ್.
Yes, yes. Yes, yes.
Lords, yesterday's matter with regard to payment of salaries. Lords, we had made a submission yesterday, Lords, that in terms of order dated 5/9/24, passed by this honorable court. Lords, last para, Lords, it says in that view of the matter, respondent number 2 and 3 are directed to route the salary to the petitioner through the outsourced agency within a period of 1 week. The petitioner is liberty to receive the salary. It is made clear that mere receipt of the salary through the outsourced agency shall not affect the contentions. Now, my lords, then, my lords, they have come before this honorable court and they have stated that the other side is not, they are not cooperating. So therefore, I just made a submission, my lords, that will come up with a solution, my lords. My lords, either way, my lords, whether it is routed directly, my lords, through the respondent number 3 or through the outsourced agency, my lords. One submission I made, my lords, it may be made clear that the contentions of the either of the parties, my lords, on the status, whether they are a contract employee or outsourced employee, on the merits of the matter, my lords, will not be affected. Now, my lords, in view of the fact, my lords, that the outsourcing agency has taken this stand, and the fact that we actually gave them the money, they sent it back to us. Now, my lords, any order that my lords will pass with regard to payment of the money directly or otherwise, my lords, is agreeable to us. But one submission, my lords. My lords, the original contract period, my lords, I'm referring to 23 point, except 23.1, my lords. 23.1, there is no dispute regarding the payment of the salary. That is we are only concerned with all the remaining 4 matters. Lords, in the remaining 4 matters, my lords, the contract period originally was from 1/8/2021 to 31/7/24. Lords, from November 23, we sought to shift them, lords, to from contract status to outsourced status. And November, December, January, my lords, salary was paid through the contracting agency, and it has been received. Now the issue is with regard to from February onwards. In the meantime, my lords, we had given an extension to the contracting agency from April 24 to September 24. Their outsourcing contract was only for a period of 5 months, from 1st of November to 31st of March, which was extended from 1st of April 24 to end of September 24, which again they said because of this issue, we are not agreeing to that. So, my lords, till September, technically, my lords, in view of the correspondences and the documents that are on record, we require, it could be said, my lords, that the services of the petitioners, my lords, could be required. In fact, after they came before this honorable court, it was only on the basis of an interim order, my lords, that they continued. So, till September, my lords, if my lords direct, the payments could be routed, my lords, either way, my lords, directly, or now that they are not saying, I will leave it to the court, my lords.
February to September.
February to September. Lords, from September onwards, lords, actually, we are concerned with 2 drivers, 1 data entry operator and 1 office assistant. Lords, unfortunately, insofar as the 2 drivers are concerned, we had 2 vehicles, lords, they have been scrapped. We don't have a vehicle. Technically, there is no work actually that we are actually taking. Only by virtue of the interim order, my lords, they continue on paper. It is not that we are also stopping them signing the attendance. So, my lords, till September, my lords, let direction be made for the dispersal of the salary. We'll clear it, my lords, that they'll get the arrears till them. And, my lords, matter could be heard finally itself, so that there could be a quietus to this. Maybe if before vacation, if my lords give a date, or in the first week itself. And the remaining, my lords, can be taken care of on that day is what my respectful submission is. At least till September, immediately, my lords, whatever, my lords, within 1 week also, we can clear the payment, so that at least they are not without any salary till September. From Feb to...
They are not working, is it?
No, my lords, we are not able to take work. There is no work there. That is the problem. The situation, my lords, we are in today is that it is an autonomous institution, which is a self-financing institution. It is not dependent on the grants of the government. Only thing, my lords, it's a society registered under Society Registration Act. They have also raised up a contention whether it is an instrumentality of state for the purpose of my lords, writ petition being maintainable. That is a matter for final arguments. As on date, for just for example, my lords, 2 drivers are there. I had 2 vehicles because they have been scrapped. There is no vehicle today. Technically, they are coming, signing the attendance and going. Because of the interim order, my lords, I cannot violate the interim order. But what I'm saying is till September, so that there could be one common date, so at least that payment could be made, and matter could be taken up next week, my lords, or in the first week of January. The rest of the things will fall in place.
Are you working?
Please, my lord.
Hello.
We are working, we will file an affidavit to that effect. We are, as and today, as of now, we are working. For a moment, your lordship may kindly see the ink page number 37 in my writ petition. Ink page number 37 in my writ petition. Your lordship get the page, my lord.
Yes.
Lord, ink page number 37, subject number 6, ವಿಷಯ 6 your lordship. ಸಂಸ್ಥೆಯಲ್ಲಿ ಗುತ್ತಿಗೆ ಆಧಾರದಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ ಸಿಬ್ಬಂದಿಗಳನ್ನು ಮುಂದುವರಿಸುವ ಕಾಯಂಗೊಳಿಸುವ ಬಗ್ಗೆ ಪ್ರಸ್ತುತ ಸಂಸ್ಥೆಯಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ ಈ ಕೆಳಕಾಣಿಸಿದ ಸಿಬ್ಬಂದಿಗಳು ತಮ್ಮ ಕರ್ತವ್ಯವನ್ನು ಉತ್ತಮವಾಗಿ ನಿರ್ವಹಿಸುತ್ತಿರುವುದರಿಂದ ಇವರ ಸೇವೆಯು ಸಂಸ್ಥೆಗೆ ಅತ್ಯವಶ್ಯಕತೆವಾಗಿರುತ್ತದೆ ಎಂದು ಮನಗಂಡು ಈ ಕೆಳಗೆ ನಮೂದಿಸಿರುವ ಸಿಬ್ಬಂದಿಗಳ ಸೇವೆಯನ್ನು ಮುಂದುವರಿಸುವ ಬಗ್ಗೆ ಮಂಡಳಿಯರು ಚರ್ಚಿಸಿತು. All the 4 petitioners are before this court in the writ petition, your lordship. This is a resolution passed by the respondents.
When was this passed?
It was in 2012, and subsequently, my lord, I would draw your lordship's kind attention to the ink page number 62, your lordship.
You are working from 2012.
Not from 2012, my lord, 2008. As against, my lord, the respondents have issued a call for notification. We made an application. We have faced the intro. They have sent an intro letter. We appear before the intro committee. A short list was drawn, my lord. This is that is drawn by the respondents' resolution, and we have been selected. All the formalities have been conducted with the respondents, and we are the petitioner service is squarely applicable under the Umadevi case, my lord, in para 53 is.
When was that process of
May I draw your lordship's kind attention to the ink page number 17, lordship. This is a call for notification.
Which year?
It was in 2007, your lordship. 22nd November 2007, the notification was issued. And ink page number in next page, your lordship, it is an intro letter. Annexure B.
Are you ready to, but someday you require a driver.
Please, my lords.
Someday you'll require a driver.
No, my
You
lords.
can't take anybody.
Please. No, my lords, if I am.
Replace him by a temporary employee.
Please, my lords. Now, in view of the latest judgment in the Supreme, if I am replacing a temporary employee with another temporary employee, my lords, that is not permitted. That is the latest, my lords, law in this matter.
They're working since more than 10
No, my lords,
years.
they're working, my lords. Here, my lords, in fact, I had the occasion, my lords, to address the court in another matter where we actually closed the printing press. We closed the printing press, my lords. There, unfortunately, there was no work. My lords, I understand there is work, I take the work. But my lords, I am not saying that let the main matter not be decided with regard to the entitlement for regularization. I am actually bringing to the notice of the court that 3 years back, when we extended their contract period by three years, that was in 2021. The work, there was work, but I'm just giving an example with regard to the drivers. I had 2 vehicles. The 2 vehicles today they are coming, signing the attendance. But I'm not actually able to take the work, and at the end of the day, my lords, I have to pay public money and it is also a question of their livelihood also, my lords, and I have to answer 14 and 16. There is no doubt about it.
No, but are you not going to get vehicles?
No, my lords, these are, the way this organization works is this, my lords, these are self-financing institutions. If they get a project, they have to generate, my lords, income out of that project, my lords, and take care of their finances. It is not a grant in aid institution, my lords, by the state government. It is a self-finance. Only thing, my lords, is it is a society registered under Society Institution Act. But ex officio, my lords, all the members of the board and members of are ex officio government employees, government servants, my lords. But what happens, my lords, is that suppose today, my lords, after September 24, all 4 are coming. There is an interim order passed by this honorable court, but I need to bring the factual situation also to the notice of this court. They are coming. We are not able to, there is no work there to take for all 4 of them. 2 are drivers, my lords. One is a data entry operator, another is office assistant. Coming, signing the attendance. And now, my lords, by virtue of the interim order, they are continuing. And tomorrow, my lords, maybe there will be an order there for that also. If we are liable, we'll have to pay. But at the end of the day, my lords, to what end is what I'm asking myself.
Let us see, you pay first till September.
Till September, my lords, that's what. My lords may pass an order till September. Other things, my lords, because there are other prayers also for regularization, that also has to be considered. We will complete the pleadings on that.
Lord, I'll file a memo, Your Lordship, in previous occasion, Your Lordship directed me to file a memo to that effect, with regard to the salary which is due, my Lord. I'm filing a memo. The third respondent has to pay the salary from November 2023. So, because I will file an affidavit to that. Because
Let's-
it's due, since by the third respondent.
Till September 24, any dues,
Just a minute.
whether it's
Let me
from
to
now.
conclude. Let me to make my submission. Lord, the third respondent is due to pay the salary since November 2023 till today, my Lord.
Just find out.
Yeah, please. Produce the document to show that the amount has been remitted to their account.
You file a statement of accounts. I'll have it tomorrow,
Okay. Monday.
Monday. Now, what about you?
Lots, the factual circumstances.
No, salary.
Salary ಸಿಗ್ತಾರೆ. Salaries, we are getting salary.
Lord Counsel, for the petitioners in seal number 23.2 till 23.4 has filed a memo and submits that the salary of the petitioners is to be released from November 2023 till date. Full stop. Learned Additional Advocate General appearing, learned Senior Counsel appearing
No,
on
no,
behalf of the,
I'm appearing for the state, my lords, on behalf of respondent number 1.
learned Additional Advocate General appearing for the state submits that they would, that salary till
September,
September 2024 would be paid, and directions may be issued by the court on this regard. Full stop. In light of the memo filed by the counsel for the petitioner, respondent to take their stand as regards to the amount to be paid to the petitioner. Relist the matter on Monday in the same stage.
please, grateful.
Petitioner may be directed to give me the copy of memo. I have not received. State equipment.
Told.
Yes. All this you settle it outside. It doesn't require court to sit and look into the memo of calculation, etc. What is paid is paid.
What is paid is
Call
paid.
them and sit and sort it out. Yes.
But in a very recent order in 2020, my Lord, they have given effect of the sixth pay commission for all the petitioners.
No done,
It
no
is
done.
on face of record wide annexure J, my Lord.
No done.
And post is for driver come office assistant. It is as against the notification and we are working against the notification.
In fact,
Yes.
Not only driver.
Now anyhow, you look into what you have paid, what you have
And the
not
court
paid.
made it clear that they are, how they are playing.
Let us see,
That
Yes.
has to be taken
That's
very
now-
seriously.
now that
We are
my-
getting it amounts to serious contempt also, my Lord.
let us see.
On
Now
the
that-
basis of records, even despite of the interim order granted by the sound court, my Lord, the third respondent has repeatedly recommended to the fourth respondent to take the
Let-
petitioner to the outsource.
no, now that my learned friend is seeking to make some submissions, but I'm actually surprised because insofar as the outsourcing is concerned, my lords, how we are, even in the AG's office also, I was surprised that the amount of money that was actually being paid here. They are paying, my lords, as per other drivers and all are paying consolidated salary of 25,000 rupees, 20,000 rupees, even the principal secretaries have. But here, for some reason, maybe they're paying them 45,000 rupees, pay scale salaries. my lords. So
Anyhow,
therefore, my
whatever
learned-
is last paid,
last page, no, my lords, on that, my lords, there is no dispute. Last paid, it is only about if not paid, since there is a calculation dispute, I'll tell them to come out.
Yes.
Please, great.
yes.
Oblige, my lord.
24 and 25, serial number 25, Balraj.
Yes.
Withdrawal of aid, my lord, the respondents have to file objections.
What is the point?
My lord, withdrawal of aid, my lord, my post is approved. And subsequently, my lord, my appointment was also approved, my lord, with aid. Later on, my lord, they have withdrawn that aid, my lord, saying that I am not qualified. I am not passed MP'd, my lord. MP'd. That is, there is, without issuing any notice and no opportunity was issued to me. And so motto, they have passed this order.
Yes.
It may be done next week, my lord.
Complete your instruction. Otherwise, I'll have to consider passing interim order. Relist the matter. The same stage on 6th.
26. Ashok or Kalyan.
6th. Yeah, the 16th January.
You have 26 months. Lord, I beg to pay for the.
Yes.
Yes, my lord, annexure P may kindly be seen.
Annexure
P, my lord, page 104, my lords. The annexure N may kindly be seen, my lord. First, annexure N, my lords. Annexure N, page 101, my lords. Pursuant to the order of the, my lord, Apex Court, referring to that, my lord, my pay was, UGC pay scale was fixed, my lord, at 16,200 as on date of my retirement.
it was fixed.
Yes, my lords. Now, my lords, I retired between 1/1/1996 to 31/3/1998.
You retired on
31/1/1998. I was drawing UGC pay scale. My lord, annexure B may kindly be seen, my lords.
annexure
B, my lords. Page 27, my lords. Annexure D, my lord, page 27.
No, you take out notice now. First time it's coming. is it?
Annexure
No, first
D,
time it is coming.
serial number 26, my lord.
Page
27, my lords. This is, my lord, GO FD2 PET dated 15/2/1999. It was applicable to all the government servants who retired, my lord, between 1/1/1997 after 1/4/1998. Prior to 1/4/1998. According to, my lord, clause 2(1), my lord, basic pension requires to be calculated in the said formula. Basic pension, my lord, as on 1/4/1998, that is, my lord, plus DA and 32.5. This is the formula to be required for fixation of the revised pension. My lord, the pay scale is fixed at 16,200 and wide annexure P, page 104, my lord.
No, 1 minute. Yes, one.
Okay. Maybe take a, file the objection, maybe after vacation, may not.
Allah, it is covered matter because.
But let him complete his instructions at least. Let him
Allah,
complete his instructions.
Allah, annexure P tav debit not.
Annexure
P, my lord, P 104, my lord.
104.
4, my lord. My lord, Lord may kindly consider, this is fixed at 7,487. Without adding, my lord, 32.5 and DA. And the last sentence, no further action is required. So, my lord, I have questioned this and I have sought for the revision of my pension in terms of 2 PT applicable to government servant. I was admittedly, my lord, was a physical director in the government aided engineering college. So, my lord, this entitles me to get the benefit of 2 PET, which is, my lord, extended, my lord, by this honorable court, wide order at an extent, my lord, in similar situated persons at page, my lord, 59, my lord, annexure K. And there was direction, my lord, to extend the benefit of, revise the benefit, revise the pension in terms of 15/2/1999 order. And my lord, pay scale was revised very recently, pursuant to the, my lord, the decision of the Apex Court in 2023. My only grievance is, my pension is not fixed in accordance with by adding, my lord, DA and 32.5. Admittedly, I was a government servant.
Let us learn counsel for the petitioner submits that the refixation of pension is required as the calculation at annexure P is not in accordance with the order passed in the case of similarly situated employees as in WP 23577 of 2014. State to take complete their instructions by the next date. List the matter in the week commencing from.
My lord, it will come, my lord, in the B group. I had made a request
Huh.
to post it in the preliminary hearing. My lord, Lordship, my candidate act of office to post it preliminary hearing only. Otherwise, it will not reach on B group, my lord. That's the reason.
ಅಲ್ಲಿ the orders ಅಲ್ಲೇ ಬರ್ತದೆ.
ಹೌದು ಅದು ಬಂದಿತ್ತು ಲಾಸ್ಟ್ ಟೈಮ್ ಅಲ್ಲೋಡ್ ಆರ್ಡರ್ಸ್ ಎಲ್ಲ ಬರಲಿ ಅಂತ
in the orders list.
ಪ್ಲೀಸ್
27, Sri Rajshekar. Same.
Yes. What is this matter?
I am due to retire in another 6-7 months. So, do they really still want to pursue the objection statement is the question, my lords. 8 months to my service.
My not matter pertaining to transfer, my lord. Lord, he has completed his tenure. Lord, he is at the verge of retirement. He is given posting in Bangalore itself. Lord, the in lieu of, my lord, the
Argument ಮಾಡ್ತೀನಿ ಬಿಡಿ ಅಷ್ಟು ಸೀರಿಯಸ್ ಆಗಿದ್ರೆ ಮಾಡೋಣ.
Yes,
I've just completed my instructions and my SOBs on record.
what is your stand?
And is that, my lord, the petitioner has completed his tenure as on the administrative exigencies. We have taken up a decision to get him.
2 years, if he is due to retire in 2 years, my lords, the administrative exigency clause will not operate.
Just take no what?
Lords, on
What was
my lords, on
submitted to me, I said-
36/2022, my lords, on 36/2022, the petitioner has taken charge as the assistant executive engineer, Whitefield E4 subdivision.
Yes.
My lords, on 19/11/23, he was placed under suspension.
19/11/23.
19/11/23, he was placed under suspension.
Yes.
Lords, at page number 18, my lords, the suspension order was set aside by the orders of this honorable court, by a coordinate bench of this honorable court. Lords, what is relevant for your lordship's consideration is page number 20, paragraph number 4.
Yes.
A reading of the said report indicate that no specific allegation of wrongdoing has been attributed to the petitioner. Observation of the report basically indicate that the incident could have been prevented if certain preventive measures had been taken. It is therefore clear that the petition cannot be attributed directly for the particular incident. The learned counsel appearing for the BESCOM, however, submits that assistant executive engineer, it was the duty of the petitioner to ensure inspection of studying voltage and road condition of various feeders for improvement of for formulating in proposals estimates, and he was also in charge of repair and maintenance works. Therefore, he would have to ultimately take
Anyhow, it was set aside.
It was set aside.
Huh.
Now, what happened? It is during this interregnum when I was placed under suspension and the suspension order being set aside. 27/11/23, my lords, the present respondent, contesting respondent, was posted to my place. Jagannath Yalagod, which is at annexure C, page number 23. Lords, this reads a very, very interesting reading, my lords. This annexure requires to be considered. Page 23. ಈ ಕೆಳಕಂಡ ಸಹಾಯಕ ಕಾರ್ಯನಿರ್ವಾಹಕ ಇಂಜಿನಿಯರ್ ವಿದ್ಯುತ್ ರವರನ್ನು ಸ್ವಂತ ಕೋರಿಕೆಯ ಮೇರೆಗೆ ಪೇಜ್ 23. ಈ ಕೆಳಕಂಡ ಸಹಾಯಕ ಕಾರ್ಯನಿರ್ವಾಹಕ ಇಂಜಿನಿಯರ್ ವಿದ್ಯುತ್ ರವರನ್ನು ಸ್ವಂತ ಕೋರಿಕೆಯ ಮೇರೆಗೆ ಅವರ ಹೆಸರಿನ ಮುಂದೆ ನಮೂದಿಸಿರುವ ಹುದ್ದೆಗೆ ತಕ್ಷಣದಿಂದ ಜಾರಿಗೆ ಬರುವಂತೆ ಸೋ ಮಾಡಲಾಗಿದೆ. Then ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿರುವ ಸ್ಥಳ, Milord, he was in the central offices. At his request, he is transferred to my place. And then he wanted to stay here despite the order of suspension being set aside. That was again challenged maybe by this honorable court before a coordinate bench. Page number 24.
There is an interim auto copy passed in this case.
Yes.
Notice the petitioner is a writ petitioner in 1205 and fifth respondent is Jagannath Yalgod. Notice, having considered this, if your lordships were to see, notice the operative portion at page number 30 at para 9. This court needs to examine whether the transfer order is in contravention of the transfer guidelines. Petition was posted as assistant executive engineer on so and so. Minimum tenure for group cadres 7/6/2000.
Just one.
Lordships.
Petitioner is the petitioner herein.
Yes.
Yes.
And Yalgod Milords is the fifth respondent in that writ petition. He is the person who, on his own request, he wanted to come and occupy the very same place for which the transfer Milords is subject matter of this writ petition.
So
Para
the
9.
writ was filed challenging his transfer.
His transfer. Not this honorable court allowed the writ petition, directed that I should be put back into the same place. That is Assistant Executive Engineer, Whitefield E4 subdivision. At page 32. 2711 is quashed.
Yes.
Then he challenges this order before the division bench. At page 33. Jagannath Yalgod Milords is the appellant. Let's kindly have a look at what the order is passed. Paragraph number 6, para 5.1 and 6. Because there is something called as issue estoppel. It is not open for the appellant to take the stand that petitioner should be posted to some other place. This is to be the position even in the transfer guidelines prescribed tenure of 2 years at a place. Since the transfer guidelines cannot be perceived to be statutory in view of the override, the effect and operation of the order of the court. Another grievance was raised by the appellant that he was not been given a posting yet. Grievance does not survive since the learned advocate appearing for the respondent KPTCL made a statement that the corporation shall give him a posting at appropriate place within 2 weeks. Statement shall be abided as expeditiously as possible. Writ appeal is disposed of. Then he challenges his order before the Supreme Court at page 39.
Satish is to be blamed. Huh? Then what happens? Then what happens?
Notice, even in Supreme Court, the last 4 lines, if the petitioner has not been given, SLP is dismissed. If the petitioner has not been given a posting despite the statement made before the High Court as recorded in para 6 of the judgment, we direct the managing director to do the needful within a period of 1 week and submit a compliance affidavit to the Registrar General. Now, this is what happens. The order which came to be challenged up to the Supreme Court is that I was displaced by Jagannath Yalgod. I was put back. Division bench confirms. Supreme Court confirms and says you give him another posting. Now, Lords, may kindly see page number 41. Serial number 1 and serial number 2. Jagannath is posted to the place of the present petitioner.
How can this be done?
This.
How can this be done? Contempt. Absolutely. You cannot overreach the order of the court. There and this is in the middle of the year also. This order is passed in the middle of the year. Also.
Yes.
How can you defend this order?
That's the reason I'm standing mum. Yeah? That's the reason I'm standing mum without any submission. Just placing my records, what was the comment sent to me.
Yes. I'll dictate a post lunch.
Lots.
Right there.
ಬೇಗ ಹೇಳಿ ಒಂದ್ ನಿಮಿಷ ಇದೆ. ಸತೀಶ್ ಯಾವಾಗ್ಲೂ ಸ್ಲೋ ಆಗಿ
ನಿಧಾನಕ್ಕೆ ಶುರು ಮಾಡ್ತಾರೆ, ಆಮೇಲೆ ಅವರು ಆಕ್ಸಿಲರೇಷನ್ ಪಿಕಪ್ ಮಾಡಿದ್ಮೇಲೆ ರಾಕೆಟ್ ಸ್ಪೀಡ್ ಹೋಗ್ಬಿಡ್ತಾರೆ.
But what is the point? Let's see.
Please.
After arbitration list in the last.
Lots. But I will take only 2 minutes.
Yes.
ಐವತ್ತ
Non-compliance.
ರೀಚು ನೋಡೋಣ ಸರ್, ವೇಟ್ ಮಾಡೋಣ. List two.
Lords,
List.
serial
Yes.
number 20, my lord. I appear
Yes.
for
Serial number,
20, my lords, 20.
which list?
List 2, my lords. I appear
Yes.
for respondents in this matter, my lord. My lords, arguing counsel for this matter, he is undertaking travel. My lords, may I kindly list the matter in 10 days' time, my lords. Objections are ready, however, we are yet to receive signatures, my lords. We have informed the other side as well, my lords.
No, but what is your objection now?
My lords, for the respondents, arguing counsel is undertaking travel. He is unable to appear today. We are yet to file objections in this matter.
Monday,
Uh,
Monday. Monday.
Lords, 10 days' time, my lord, 17th may be taken.
20.
For objections, how many days you require? In arbitration, CMP reference matters, you
My
can't
lord,
ask.
we are also to acquire a few documents from the
No,
client.
correct, I'm saying, what is the objection for reference? Now the apex court has put it in a very narrow compass. I'm not going to enter into other aspects. Next week you file whatever you want to say. We can't enter into any detailed consideration at this stage.
My lords, a week's time may be granted, my lords.
Relist the matter on next week.
11.
11th.
Please, my lords.
Serial number 1.
Just start.
List two, serial number 1.
Yes,
2 weeks, my lord, I have
weeks
filed a
time
NOC.
granted for necessary compliance.
Please.
Serial number 2. Ragopal Naidu, serial number 2.
Weeks time granted for necessary compliance.
3.
Weeks time granted for taking up necessary steps.
4.
We are withdrawing the petition.
Counsel for the petitioners filed a memo which reads as hereunder. In light of the same, petition is dismissed. Liberty as sought for is preserved.
By agent, serial number 6. Version.
For the petitioner.
He has not informed you. see. Huh? ಇಲ್ಲಾಂದ್ರೆ ಬರ್ಲಿ ಕರ್ಸೋಣ ಅಷ್ಟೇ.
Serial number 6, my lord.
6.
For the petitioner, in this case,
ಅದು ಯಾವ ಡೇಟ್ ಕೊಟ್ಟಿರ್ತಾರೆ? You will have a short date. Next time you must be ask somebody to be present at 10:30. No, 10:30 only he has moved it. Yes. No, I request counsel that minimum courtesy when you move at 10:30, you must inform your colleague. You can't expect a person to not know and you just take your date and go. It doesn't, it reflects poorly on your own, on yourself because he's your brother. How you are waiting, the other person also will be waiting, isn't it? So when you're moving at 10:30, you must notify the other side, at least by a message, so that the other is informed.
Serial number 5.
Yes. Yes.
serial number 6 for the petitioner, my lord. The parties are willing to settle the matter.
You appear for respond for the sole respondent, is it?
Yes, ma'am.
Not counsel so and so undertakes to file wakalat for the respondent. So when shall we have it? After 2 weeks.
Yeah, the parties are willing to settle, my lord. If we can.
List the matter after winter vacation. Yes.
7.
For the petitioner in the case, my lord. My lord, this matter has been already settled and we'll file a memo for withdrawal
When will you file?
today, during the course of.
Counsel for the petitioner files a memo and submits that the dispute has been settled. In light of the same, petition is dismissed. Yes.
8,
For the petitioner, my lord, we have taken steps. We have furnished the new address. We have taken steps, my lord.
We, counsel to the petitioner submits, needful is complete, office to verify and issue notice.
9,
We are filing a memo to bring the, alerts are already on record. So we are filing a memo with that respect.
Counsel for the petitioner has filed a memo and submits that the legal representatives of respondent number 1 are already on record as respondent number 2. In light of the memo, necessary endorsement to be carried out in the cause title. Relist the matter.
17,
Yes.
10,
For the petitioner, my lord. The sole respondent is the, so we are filing an application to bring his LR on record.
Issue notice to the respondent. Issue notice on application filed to bring the legal representative of the sole respondent on record.
Eleven. Serial number 11.
For the petitioner.
Yes.
This is in reference to the appointment of the arbitrator. Your Lordship. It's in page number 58 and clause 15. Your Lordship.
Any objections? And that we'll see, we dispense with the, finally that has to be produced.
Lordship, we have a contract where the
So the
contract,
agreement original is with whom?
it's with them, Your Lordship, the respondents.
Relist the matter on date.
Please,
Yes.
12. Serial number 12.
Yes. Office to put up report regarding notice issued to R3. Statement of objections to be filed by the next date. List the matter in the week commencing from.
6th.
Yes.
13. 6th.
Appear for respondent, my lord.
Yes.
We have filed wakalat for R2 to R4, which is not forthcoming in the cause list. And we'll file the statement of objection, my lord. We
Yes.
need 3 weeks time.
Learned counsel. Wakalat is filed in whose name?
All
No,
respondents.
name of the counsel.
Shri Hari Kutsa.
Learned counsel, so and so, undertakes to submits that wakalat has been filed for respondents 2 to 4. Objections, if any, by the next date. Release the matter in the week commencing from.
6th of 10.
Yes.
My lords, there's nothing to dispute with respect to admission of the agreement, my lords. Next week, my lords. Now that, my lords, Indian stamp judgment is very clear.
But our list is.
We'll file the statement of objection, my lord.
Let them file, let us see.
Yes, my lords. 18th, my lords, from a request.
When do you want?
3 weeks actually, 3 weeks time, my lord.
In the week commencing from.
6th of January.
Yes.
14.
7th.
6th of January.
Yes.
14.
Office to put up a report regarding notice issued to the respondent.
15. Respondent Sunday. Actually, I was on Monday. The matter was already decided. Here the PMP was filed.
We are hearing some matter with a similar legal issue. After that is decided, we can take it up. Relist in the week commencing from.
6th of January.
Yes.
16. Meter.
Lordship, yesterday we were asked to file a memo about the notice received from the Commercial Taxes Department. So placing the memo. Your Lordship.
Counsel for the petitioner files a memo, same is taken on record. We'll have it on, let him come in his presence, we can pass some order. Please,
I'll have it some other day.
please.
Relist on.
16.
In which matter? Yes, next.
17.
Next Thursday.
Waiting for the petitioner, my lord. While the IA for include the association, my lord. Last night informed to Honorable Court Director to file wakalat for association also. I informed the association, my lord. Till today, I not filed any wakalat.
Issue notice. Let
Already
notice
issue notice was served, my lord.
Application allowed.
Huh.
Notice on the petition.
Please, my lord. Already served, my lord. Impleading application was
Served. ಹಾಗಾಗಿ application has to be no. Maybe.
on the bylaw of the association only. I filed for
No. Now notice on.
already notice served, my lord, to the association.
So then we'll allow the IA.
Yes.
But if they don't come, then what happens?
After allowing the application, notice has to be issued.
No, but they, no, correct. But now they're already notified of the proceeding.
Of the proceeding. They have to propose completing them.
No, maybe, but if they're keeping away, then what's the point now? No, then at least you try to inform them.
They are very close.
They're close, but yet afar.
To file wakalat.
Huh?
I already informed the direction, my lord.
I don't know, you try once again.
Please, my
You
lord.
want to take out notice by way of hand summons, I'll permit you.
Please. IA may
Petitioners
be allowed, my
permitted
lord. I
to-
will file and give next amended CMP copy. Because
So
in
we'll allow the impleading application.
Please, my lord.
IA 1 of 23. That notice serve agide madam. IA 1 of 23 has been filed by the petitioner seeking to implead the association. Notice issued has been served. Now counsel for the respondent submits that they have no objections for allowing the said application. Accordingly, IA for impleading is allowed. Necessary amendment to be carried out to the cause title.
Please. And
This-
summons may be.
Petitioner is permitted to take out notice on the main petition to the newly added respondent by way of hand summons as well.
Please, ma'am.
List in the week commencing from. Yes,
Obligement. Permitted to amend.
yes.
IFA for the petition.
Yes.
Respondent number 1 is a partnership firm, Lord. Page 20 may kind. Twice he sought time, Lord. There's nothing to object.
Not correct.
They're only trying to buy time.
No. Mainly in these matters, we can't enter into any point, including limitation regarding claim, is a matter to be raised there only. I'll have it next week. Whatever you want to file, you file.
Lots
No
of
further.
that finally time is granted.
As a
Lots
last
kindly
chance.
indicate.
As a last chance, relist the matter on 12.
Okay.
All contentions, I will keep it open.
Very well.
Yes.
19. Subject DJ 19.
List after winter vacation.
20 and then 21.
Appearing for the petitioner, Your Honor.
Yes,
The respondents were supposed to file objections.
yes. Relist the matter on.
12.
Yes.
22.
Grateful, Your Honor.
22. Vandana PL.
He's not available. He's in, he has, no, some other, he has an, now he has another assignment, so he's not taking up matter. Yes, find out. Relist the matter next week. He's appointed to some commission.
So all his assignments are being redistributed. So you find out anybody else?
Sorry.
Yes,
23.
Favor the petitioner.
yes.
There is no arbitration clause, that is deleted. The upgrade is not the-
So then you file your statement.
this time.
Yes. Learned counsel for the, now you are filing, is it?
This time.
Learned counsel for the respondent submits that statement of objections will be filed. Relist the matter. Yes.
Grateful.
24.
I appeal for petition. This is regarding appointment of arbitration.
Yes.
In the last occasion,
Relist the matter.
on 6th,
Allowed, when do you want it?
within 1 week, where notices.
In the week
legal
commencing from.
notice.
Yes.
Date
25, 6th of January. 25, 11 years.
Yes,
Here for the petition, lords.
yes.
They have filed vakalat for lords. The respondent has filed vakalat, lords. It's pertaining to lease agreement, my lords. I am the lesser landlord, my lords. Subsequently, my lords, we have issued notice to
Let us see, one opportunity. Objections, if any, by the next date. No representation on behalf of the respondent. It's made clear the respondent remains absent on the next date. Matter would be proceeded with in the absence of the respondent.
kindly, my lords.
Relist the matter on.
17.
Grateful.
Yes.
Number 26. Mitchell there.
Here for the petitioner, my lords. On the last of this is matter relating to two contracts wherein arbitrator appointment has been sought. On the last occasion, time was taken by the respondent indicating that they're exploring settlement. Meeting did take place between both parties on the 3rd of October, but none of the claims which were raised in these in the subject CMPs have been discussed or settled. Now, therefore, arbitrator might be maybe appointed, my lords, in the matter may be.
Say, to my party, want one go for amicable. First, please for amicable discussion. See, I have sent one of them.
No, no. Correct, no. They're saying there's still a possibility, so why don't you see what's in the.
In fact, a meeting did take place on the 3rd of October. And it was specifically told to the petitioner that that other claims relating to delays which have been raised will not be considered for settlement. In any event, my lords, my only submission is both parties may even continue to explore settlement even after the arbitration has been commenced. So if the arbitrator may be appointed, settlement talks can happen. If it is actually happening, it can happen simultaneously, my lords.
Statement of objections, if any, by the next date. Relist the matter on.
18.
Yes.
Obliged, my lords.
One. Number 10, Satish K.
Lord, matter pertaining to me, Lord, compassionate appointment. Lord, only to refresh my memory, my Lord, the petitioner is the, Lord, the married daughter. Father died, my Lord, on 22/7/2022.
On 22.
22/7/2022, father died.
Yes.
Lord, petitioner and another, Lord, sister are the, my Lord, children to their parents. Lord, the mother and another sister gave a, Lord, consent
for appointment of the petitioner, since, my lord, the affidavit also indicates that she is residing with the parents, Lord, when her father died. Lord, on 27/1/2023, my lord, petitioner was appointed on compassionate ground. Then, my lord, the notice was issued to the petitioner on the first occasion that you are a married daughter, you are not entitled for compassionate appointment. I replied stating that, my lord, there is an amendment to the compassionate appointment rules. Not thereafter, not on the second occasion, Shoka's notice is issued on 2 counts. One is, my lord, I was not residing with the parents. Another is, my lord, I was not dependent.
Yes.
Lord, I replied, the impugned order is at Annexure N, page 52, which says that, Lord, the order of appointment issued to the petitioner is cancelled, and direction is issued that, Lord, if my mother applies for compassionate appointment, Lord, her case will be considered. Lord, I am working, Lord, for the last about 2 years. So far as, my lord,
Let us have a look at the rule, what it says regarding dependency.
dependency. Please. Service many Lord, as far as residential residing with the parents, my lord, that may not be have much relevance. But, Lord, dependency is concerned, my lord.
But this exercise you have not done. In your notice, you have not calculated.
Lord, before that, Lord, Lord, my learned friend is right in saying that, Lord, dependency is to be looked into, and the respondent corporation has not seen the dependency. But my learned friend has read the definition which has undergone a change in the year 2021.
No, correct. So in that, insofar as that married daughter will take note of.
Illa, there is a, my lord,
Another amendment is to the effect.
Lord, kindly take the amendment dated 9/4/2021, which is filed along with the, my lord, reply statement. Kindly come to, my lord, page 18.
Yes.
But your lordship got amendment to rule 2. 1A, dependent of a deceased government servant means a member of the family of a deceased government servant who was living with the dependent, who was living with and dependent on the deceased government servant, and who fulfills the conditions specified in the explanation to sub-rule 1 of rule 4. Lord, we have to fall back on, my lord, rule 4.
Yes.
One, appointment on compassionate ground under these rules shall be subject to following conditions, namely, 1, that is, my lord, the amendment which has taken place in the year 2021 is relates to, my lord, sub-rule 1 of rule 4. The family of the deceased government servant should be in a financial crisis or destitution.
Yes.
Then, my lord, a family of a deceased government servant shall be considered to be in financial crisis or destitution if the recurring monthly income of the family from all sources is less than the total emoluments, including dearness allowance, house rent allowance, and city compensatory allowance admissible at Bangalore on the average of the minimum and the maximum of the scale pay of the first division assistant as on the date of making the application for compassionate appointment. Lord, it is the Lord formula which is not evolved by the government, that whether deceased government servant's family is in financial crisis or not, how to measure is the Lord, if somebody is getting the.
But this calculation also has to be done. This formula under 4.1, some formula is provided. So that you will have to put forth after getting information from him and tell him that it has to be, it must fall within this formula. They have not filed. No, correct. So my don't mention names, madam. Yes. What does it say? What does it say? Yes. Just 1 minute. Now, regarding your residence, you have given any document? Satish,
Please, my lord.
regarding residence
Yes,
along with deceased,
please,
what is the document?
my lord, kindly take, my lord, rejoinder. I have produced. There is no much dispute with regard to, my lord, place of residence. Even after marriage, my lord, we were with the, my lord, parents. Dependency, my lord, they have not evaluated.
Annexure P.
Yes. Annexure P and Q.
P and
P is the Aadhaar card of, my lord, petitioner, which indicates the address. Annexure Q is the Aadhaar card of deceased father.
now we can do one thing. Now you have a point in which you are saying both conditions have to be satisfied. One is residence and second is dependence, and that dependency in terms of 4.1. Now we will set it aside and remand it back with the direction you can hold an inquiry. And the inquiry should record a finding on both the points. You give him a notice, let him give whatever reply he wants to give, whatever document, and let the inquiry report address these 2 points. Let it be placed before you, let him be heard, and you take a considered decision. Instead of entering into merits of the matter, considering that she's already working, anyhow, that is a correct, but in the termination, now they claim that annexure P and Q, P and Q. Okay, let them give whatever other document they have. They correct. So that's why you calculate according to 4.1 and you take a call, whatever document he has to show that he was residing with the deceased as on the date of death, 1, and 2, that he is not a dependent in terms of, that he is a dependent in terms of 4.1. Let him place before you, you give him an opportunity and record a finding, and then take a decision. The petitioner. Correct. He has to, but in terms of 4.1, you have to make a calculation and then record a finding. But your husband's income also will have to be taken.
Yes.
Though the rule 4.1 says like that, you must also place before them husband's income, let them take a decision.
Yes, not dependency. Burden is on me to prove that I was dependent on that exercise. They are not.
The petitioner has sought for issuance of a writ to set aside the order dated 10/7/24 at annexure N, whereby the respondent authority has rescinded the order of appointment granted on compassionate grounds by recording a finding that the petitioner was not a dependent on the deceased, has failed to demonstrate that the petitioner was a dependent on the deceased. The said order is called in question on various grounds. The petitioner has filed a rejoinder statement and produced various documents. And it is submitted that in terms of the rules, petitioner is required to reside along with the deceased, and to such effect, petitioner has relied upon annexure P, which is the Aadhaar card, and submits that the address of the petitioner is same as that of the deceased. Insofar as the aspect of dependent of the petitioner being a dependent, counsel for the petitioner submits that the word dependent is to be read in terms of Rule 4.1 of the rules.
Please.
And the explanation provides for a formula for determining the dependency, and such finding is absent in the order, rescinding the order of appointment. Land counsel for the respondent, so and so, has vehemently argued and submits that there are twin conditions to be satisfied, namely one as regards residence with the deceased, two, that the petitioner was dependent on the deceased in terms of Rule 4.1. It's further submitted that the order passed is a speaking order and takes care of the relevant reasoning. Land counsel for the respondent also relies on order of the coordinate bench in passed in WP 27347 of 2023, and submits that the petitioner has not fulfilled the twin conditions required under the rules. Full stop. After having heard both the sides, at the outset, it must be noticed that the petitioner, having been appointed on One 2/23,
Please.
has continued in service.
27/1/2023.
27/1/2023 has continued in service till date. Full stop. Though the impugned order rescinding the order of compassionate appointment was passed, in light of the interim order passed by this court in the present proceedings, petitioner has continued to work. Full stop. Next. In terms of the Karnataka Civil Services, within bracket appointment and compassionate ground rules 1996. Well, the amended rules,
Please.
As amended, the definition of the term dependent is under Rule 2A. Is under Rule 2A. Full stop. The said rule refers back to Rule 4, Sub-Rule 1 for the purpose of determining the aspect of dependency. 2A reads as follows. 4 Sub-Rule 1 and explanation reads as follows. Next. The disentitlement of the petitioner would be only if the petitioner fails to demonstrate, one, that she was not residing with the deceased and that she was not a dependent in terms of the rules. Next. Needless to state, as contended by the respondent, both the twin conditions are required to be demonstrated by the petitioner. The order passed, though refers to the aspect of residence, was not, the order passed, though refers to the aspect that the petitioner has failed to demonstrate she was a dependent on the deceased. However, taking note of the documents filed along with the rejoinder as regards assertion of the petitioner regarding residence, as well as noticing that the order does not refer to the criteria for determining dependency in terms of explanation to 4 sub-rule 1. Appropriate to set aside the order at annexure N, remanding the matter for fresh consideration. Upon remand, the authority concerned is to issue notice to the petitioner and determine the twin requirements of the petitioner being a resident along with the deceased, as well as being a dependent in terms of 4.1. In terms of Rule 4, Sub-Rule 1, and the explanation. Needless to state, the petitioner also to advert regarding the income earning capacity of her husband, which would have a bearing on determination of the aspect of dependent. Accordingly, the proceedings are remitted for consideration in terms of the observation made above. Yes. Yes.
Within a time frame.
Huh?
Within a time frame.
Marty, you are living on oxygen. Ventilator. Yes.
Serial number 16.
Obliged.
My lords, this is a matter where matter pertaining to lineman's post, where women's reservation was removed for 30%, my lords, that they have questioned it by way of amendment. Lords, I've secured some instructions. We need to put it in writing. I'll place it on record. The only reasons what was briefed to me was, my lords, there were two judgments of this honorable court. One is Sakama and one is Janaki, where similar notifications were questioned, not the notification where the reservation was reduced. At that point of time, women were, they were not allowed to participate in the lineman post. At that point of time, a report was submitted to the court by an independent agency from also ISAC is an independent agency. It submits a report why that particular post cannot be reserved for women as such. But my lords, the notification before my lords does not preclude them from participating. They can participate. What happens is the reservation of 30% is given for women across all the streams under the General Recruitment Act in the Karnataka government. My lords, the reservation of women cuts across as a horizontal reservation, even in general, SC, ST, and other categories. Now, what happens in this particular post, my lords, what I was briefed, the lineman's post, this 30% reservation
Lineman is a misnomer.
Yes, they should have made it just, should be treated as linewoman also.
Yes.
Now, what happens is this 30% reservation, which is provided first in primarily, they do not receive as many applicants for that 30 post. And when these women are appointed, my lords, what's happening is they are not ready to work in the fields. Immediately, they're requesting for desk jobs and other things. So what's happening, we got a letter from the KPTCL that they are finding it very difficult where they do not have people in the field. If we call for 100 posts and 30 posts are reserved for women, we cannot take anybody but women for that post. And even when people are applying, less women are applying. And even the physical, there are two tests, my lords. One is a written test and one is physical. In the present case, my lords, the respondent number 1 and 2, they have filed statement that the petitioner herein did not clear the physical test. They have to clear, there are 4 tests, at least 3 they have to clear. She has not cleared, so even otherwise she's not eligible. They have produced the records. But my lords, to answer the question of why the reservation was diluted, like they can participate, but the reservation was removed by the state on the recommendation of KPTCL and on considering the reports that these women are not actually working in the fields. The moment they are recruited, my lords, they are seeking for desk jobs and other jobs because it's a very difficult job.
Like in High Court recruitment.
I
They don't want to work as orderlies. They want to come to the
Yes.
court.
So the department of KPTCL, my lord, they're finding it extremely difficult. What happens is in the night, sometimes the power goes and they have to climb the pole and fix the thing. So women are not ready to work in those hours. There's so many other difficulties. And we have taken this decision based on an independent agency's report. I'll place all those things on record, my lords. It can be heard.
So when do you want it? After vacation? Or
These, my lords.
statement, now statement is not filed or additional?
By state, it is not filed. We were implemented later, my lords.
State to file the statement of objections released in the week commencing from 13th.
Grateful.
Hmm.
Twenty-seven. Sri Rajshekar, 27.
Here for the respond number 4.
Yes.
Not on facts, not the I was posted to the place of the petitioner in an earlier round of litigation, which was subject matter, my lord, quashed. Division bench affirmed and Honorable Apex Court also dismissed the SLP. Not reason for quashing the order of transfer at that relevant point of time, my lord, it was premature. May I request my lords to kindly look at, my lord, the order at annexure D is the first, my lord, the order passed by this honorable court questioning the order dated 27/11/2023. Page 23 is the order of posting. Annexure C, 27/11/2023, posting this respondent to the place of the petitioner. Then, my lord, reasoning starts from para 9.
Annexure?
Annexure, my lord, D, page 24. Reasoning of this honorable court is at para 9.
So page number is tally agala. Annexure, which you are referring to, which order? 27348. You're referring to?
Not order passed in writ petition 1205 of 2024, my lord.
At page 30.
Yes, my lord, 30.
Yes. Yes.
Not para 9. Not this honorable court holds that, my lord, it is premature. Therefore, posting of the private respondent is quashed. On that ground, my lord, it was quashed. That is the only ground, my lord. Minimum tenure is 2 years. He had not completed 2 years. Therefore, my lord, it was quashed. But now, my lord, the scenario is changed.
The tenure completes when?
Tenure is completed, my lord.
When?
Tenure completed on 30/6/2024. Impugned order is dated 30/7/2024. 2 years is the tenure, my lord. He is in the cadre of assistant executive engineer, which is a group A post. Minimum security is, my lord, 2 years.
The order of initial posting,
Not initial
36,
36,
2022.
Not posting order is dated 27/5/2022. His initial posting to the present place is dated 27/5/2022, which shall come into force on 36/2022 on account of, my lord, retirement of
yes,
one Mr. M.M. Sali.
yes.
Therefore, my lord, he has taken charge in the said place on 36/2022. Impugned order is dated 37/2024. 2 years, 1 month he has worked. Lord, under the impugned order, may I request my lords to kindly take, my lord, annexure G, page 41. Lord, he is given posting. Lord, I can understand if he is without posting. But he is given posting at Bangalore.
No, but again, this is in the middle of the year. Or
Lords,
permissible.
No, 37/2024 was the last date permissible, my lord, under the new transfer guidelines. That was the last date.
What about his the submission that
Lords, page 52, my lords. I don't think there is anything for them, but he wants to argue, but still he is arguing. Page 52, my lords, is the transfer policy.
yes,
What holds good, my lords, for the transfer policy of 2 years holds good for the other. Page 52, premature transfer or delayed transfers. Minimum period of service of a government servants which may at a place be extended or reduced in the following circumstances. When a government servant who's completed the maximum period of stay at a place and due for transfer as less than 2 years of service left for retirement. I'm retiring in the next 6 months. But, my lords, if your lords is going to see the interim order, that is a ground on which this honorable court granted the interim order. The transfer policy violation at an earlier instance was relating to 2 years. The transfer policy violation at the present instance is because I'm due to retire within a period of 2 years on the date when they want to transfer me. What is held, my lords, in the earlier judgment dictum holds good even at this instance.
That may not be correct. That may not be correct. But in the earlier round, transfer order was quashed solely on the ground that it was premature. That ground is not available, my lord, to the petitioner in the present litigation. Lord, my submission is, my lord, a government servant who has completed the tenure, Lord, cannot say that, Lord, I must cling to a particular post till my retirement. Is the, my lord, ratio laid down by this honorable court? Kindly take, my lord, page 28, annexure R2. Lord, in a similar matter, my lord, similar situation, this honorable court has considered page 28, annexure R2, arising out of, my lord, the very same corporation. That is the, and
along with your memo.
Lord, reply statement filed by me, my lord, on 16/10/2024.
Yes.
The para 2, page 29.
Namde order.
Para 2, my lord. It is submitted that respondent number 4 has been posted to the place of the petitioner. Petitioner submit that he is due to retire on 31/3/2023, which fact is not in dispute. Lord, kindly come to, my lord, the para 6, page 31. Heard both sides. It is not in dispute that the respondent KPTCL is aware that the petitioner is physically challenged, as is evident from the photograph at so and so, which is not in dispute. So also the respondent is also aware that petitioner is due to attain superannuation and so on. So normally, while passing an order of transfer, authorities are to keep in mind all these aspects, including the aspect as made out in the present case relating to superannuation of the petitioner, and also that he is physically challenged. Of course, clause 9A does stipulate the ground for extension of tenure after following the procedure in clause 9B. It would come out from a plain reading of the transfer guidelines 2013 that case made out by the petitioner on the ground of extension of tenure, considering that petitioner would be attaining superannuation on 31/3/2023, he is physically challenged, both of which aspects are not in dispute, is to be considered after following so and so. If the petitioner makes representation to the respondent seeking for extension of tenure, the same is to be taken note of and considered as per law. If the same is exceeded to, then the procedure under so and so to be followed by the KPTCL. Therefore, my lord, on that ground, my lord, direction was given. My lord, that direction may not be, my lord, available to the petitioner since he is, my lord, posted in, my lord, in Bangalore itself. But I can understand he is due for retirement, posted to my lord Kalaburgi. He is in, my lord, given posting in, my lord, Bangalore.
But your guideline says from one room to the other room is transfer.
Transfer. It is a transfer. Lord, even Lord, under the 25/6/2024, Lord, this honorable court has considered, Lord, the definition of transfer is amended in the new transfer guidelines. Lord, this honorable court says that Lord, posting movement from one place to another in the same headquarter also, Lord, amounts to transfer. The word redeployment is, Lord, used in the new transfer guidelines. But this one court has held that it amounts to transfer. But another reason for transfer is, my lord, there is a criminal case against the petitioner. My lord, page 34, annexure R3.
Correct, but for that there must be a recording that 5, guideline 5. If you are going to resort to disciplinary proceedings,
no,
then in order must refer to guideline 5.
Only one submission. FIR is registered. He questions the validity of FIR. Page 38, annexure R4. This honorable court, coordinate bench, considers the order passed by this honorable court in the matter pertaining to suspension, considers that and dismisses the petition filed by the petitioner challenging the FIR on the ground that case is made out for investigation and he is asked to face the investigation. My lords will find the
you didn't file any impleading.
No. Impleading in ಹಾಕಿಲ್ಲ. By that time transfer ಆಗಿರಲಿಲ್ಲ. But this
yes.
And para 9, page 47.
He's unlucky. Otherwise, normal course he should have got to stay.
True, my lord.
Yes.
Since the senior counsel for the petitioner has placed heavy reliance on the order passed by the coordinate bench setting aside the order of suspension, it becomes germane to notice the said order. Then, my lord, after quoting the report, my lord, ultimately, para 14, at page 53,
yes,
it only says that, my lord, there is a negligence on the part of the petitioner herein. A case is made out for investigation, but at this stage, FIR cannot be quashed.
But suspension was quashed.
Suspension was quashed. But referring the order of suspension, but the coordinate bench refuses to quash the FIR.
Yes.
Then, my lord, I don't say, my lord, that the Honorable Uploka Ekta has also taken note of this incident. Annexure R6 is the, my lord, order passed by the respondent corporation to initiate inquiry against the petitioner, which is at page 59. Page 59, my lord. In respect of the incident, my lord, which is the subject matter of FIR.
Yes.
My lord, in this background, my lord, clause 5 of the transfer guidelines, which is produced by my lord petitioner, kindly come to my lord page 49 of the petition. And person who is facing the inquiry, there are serious complaints, but there is a bar to hold a executive post. Page 49 of the writ petition, my lord. Page 49, clause 4, subclause 3.
Yes.
The government servant against whom there are serious charges and against whom departmental proceedings, criminal proceedings are initiated or pending or prosecution is being contemplated shall not be posted to sensitive executive posts and should be posted to non-executive posts where they cannot interfere with the investigation against them. Further, a government servant against whom departmental inquiry criminal case is pending should not be posted to a post requested by him. Lord, the post held by him is, my lord, operation and maintenance, which is an executive post. Now, my lord, under the impugned order, he is given, my lord, non-executive post in Bangalore because of the bar contained, my lord, provided under clause 4.3. He is facing criminal case. He is facing departmental inquiry. Therefore, my lord, he cannot hold the executive post. This need not be, my lord, referred in the, my lord, file. This can be a defense for the private respondent to say, my lord, he cannot hold an executive post. My lord, another decision of my lords, my lord, the Kalburgi bench at, my lord, page 16 of the reply statement. Lord, there, my lord, government servant had completed the tenure. Lord, the post was earmarked for senior sub-registrar. Sub-registrar was posted. Lord, he challenges on the ground that person who has come to his place is not eligible. Lord, in that context, my lord, this honorable court has held that once tenure is completed, Lord, defective posting cannot be the reason for challenge. My lord's decision is at, my lord, page 16, para 12, para, my lord, page 21. If there is any defect in the order, that cannot be the sole ground. The grievance of the second respondent is that by virtue of the order of transfer, petitioner who is a holder of Group C post has been transferred to perform the functions of a post designated for Group B. Clearly, the second respondent's right to question the order of transfer on the sole substantive ground of defect in posting the petitioner to the post of sub-registrar at Vijaypura cannot be entertained, as the second respondent seeks to rely primarily on the defective posting of the petitioner, and it cannot be said that legal grievance regarding defective posting is sufficient to challenge his order of transfer. But in there, my lord, he had completed the tenure. But here, my lord, he has completed 2 years, 1 month. Therefore, my lord,
yes, Ravi Shankar, what do you say regarding this point of the criminal case pending?
May I just pass this on, Lords? Just. Lords, your lordships, have already, Lords, expressed. There is a requirement of a transfer being made in terms of clause 4.3. 4.3 transfers are completely different. It is not coming within the purview. But now the first and foremost question is this, my lords. It's a very short judgment.
Have you sought for any retention?
Yes.
You have sought?
Yes, I have sought for retention. Lords will get, my lords, the representation made by me at page number, page number 46. Page 45 on page 46. That representation is made. Page 44 and 46. I stand corrected.
before completion of tenure.
Yes.
Okay, then you decide, you would consider it.
Lords, if your lords is going to just see this judgment, my lords, because more often than not, this is a very short judgment, my lords. The private respondent who would be the beneficiary of the transfer order would resist on the ground that there are allegations against the person who is seeking to challenge the order of transfer. Lords, paragraph number 2, learned counsel for the petition submits that after the transfer, both the petitioner and the respondents have taken charge. Their transfer is on complaint, and therefore, though it is a premature transfer, it is permissibly in law. Merely because the officials take charge, that would not take away the right to challenge the order of transfer. The next sentence is important. Similarly, if an official is transferred on complaint, the beneficiary of the order of transfer cannot make it a ground to sustain the order of transfer. He is precluded.
That is, now, the only part is he has made a request for extension. And in terms of the transfer guidelines, he is entitled for such consideration. Decision is yours. So in light of that, we will set aside the transfer order and then you take a decision on that.
Just two judgments, my lords, of the
decision.
coordinate benches, which specifically dealt with the transfer in the fag in the dusk of life. Lords, may I just pass these two judgments?
Based on these, there are few judgments of the coordinate bench, Your Lordship, wherein the order of transfer, if it's on the fag end, like a month period of 4 months or 6 months, the transfer order to continue, and immediately after the completion of that particular period, the respondent who's been posted to that post to be considered is a few judgments which the coordinate benches.
I am myself a beneficiary of such order, my lords.
Yes.
There are judgments. Right?
If that post is so powerful, then you can.
That is the problem where we are standing. There are few places of those sorts which are called in question, which makes us sitting on a burning seat.
So we'll say you can consider. What do you say? When are you retiring?
My lords, August.
July or something.
July. 31st of July.
July. As per the biodata available with us, it's July.
31st of July.
Yes, Satish.
May I request this, my lord, your lordship may say that, my lord, impugned transfer order shall be given effect to, my lord, on 31/7/2025. Win-win situation for both of us.
Yes. After.
Please.
We don't.
ನಾನು ಹೇಳಿದೆ ಅವ್ರಿಗೆ ಮುಂಚೆ ನಾ ಹೇಳ್ಬಿಡಿ ಎಷ್ಟು ಹೇಳಿ ಮುಗಿಸ್ಕೊಂಡ ಅಂತ.
Maybe on a lighter note, my lord, maybe this judgment will come to Satish rescue to place it before other courts.
Their calculation is ಇನ್ನೊಂದ್ ಸತಿ ಹೋಗ್ಬೇಕು, ಅವ್ರು ನೋಡ್ಕೊಬೇಕು. ಅಲ್ಲ, that's double jeopardy.
The number of judgments he has placed on record. This will be one of the judgments again where we departments will be facing in the later stage.
The petition has sought for, and I don't know why it goes up to Supreme Court. Supreme Court also passes speaking order.
May I seek your lordship 6?
Yes. The petitioner has sought for issuance of writ of certiorari to set aside the impugned transfer order passed by the second respondent at annexure G, whereby the petitioner has been transferred which serial number?
Serial number 1 and 2, my lord.
1 and 2.
Page 41. Serial number 1 and serial number 1 is the private respondent.
Whereby the petitioner has been transferred to the place of respondent number 4, and respondent number 4 is posted to the place of the petitioner.
Please.
Full stop. Out of the several contentions urged, it was pointed out that though tenure of the petitioner was completed, however, in light of the transfer guidelines, in specific guideline number 7, isn't it? 7A, the petitioner has made a request in terms of the representation at annexure H.
Page number 44 and.
Annexure H.
H and H1,
And
my lords.
accordingly, H and H1. And accordingly, the authority ought to have considered such a extension of tenure instead of passing the impugned order. Full stop. After hearing the matter for some time, learned counsel for the respondent submits that if the order of transfer is deferred till the time of superannuation of the petitioner and given effect to immediately thereafter, the grievance of the respondent to some extent would stand satisfied. And counsel for the respondent 1 to 3 submits that if such equitable arrangement is worked out, they would have no objection. In light of the same, the order of transfer at annexure G is stayed till the date of superannuation of the petitioner and immediately thereafter would stand revived. Accordingly, petition is disposed of.
Official by coordinate benches in other similar circumstances.
Such equitable orders are also are made, taking note of similar such orders passed by the coordinate bench in identical circumstances.
Transfer order may be given effect to on 1/8.
Immediately after
Immediate-
superannuation.
Immediate-
Lords may specify the date, but it may not.
So when so what is the date then?
31/7. 30th/7.
1/8.
Yes.
July 23.
30/7/2025.
Last date is 31/7/2025.
31/7.
July 31st is his last date as per the biodata available with.
1/8/2025.
Please.
Transfer order to be given effect to as on 1/8/2025.
Yes.
Yes.
Lord,
Then till then,
my lord, I will continue in the present place. But petitioner will continue in.
So there's no disturbance, both are placed in there.
yes, yes, yes.
One request would be, my lord. Your lordship may observe that, my lord, my minimum tenure start from 1/8/2025.
No, no, no.
It's
How
under-
is it? We'll see. Yes.
Much of it.
Thanks.
28. Ashan gave it.
I appear for the petitioner, my lords.
Yes.
Matter, my lords, where the pensionary benefits, my lords, they have to pay interest. And in terms of the government order, my lords.
File the objection.
Huh?
Get the
Alien?
instruction, 2 weeks, my lord,
The lien objection is
withheld of amount. I have to get the instruction, then.
no, I'll say you pay interest
Yes.
and recover it from the concerned.
Concern.
If you find that there is some there is any inaction amounting to misconduct of the concern. It's only on
Let's,
interest. Only on interest.
Interest and the balance payment, my lords.
How much balance?
82,121. That my lords will get it at annexure T, my lords.
No, last time it was mentioned that they'll give it back.
Last time, my lords, they said, my lords insisted that some interest amount would be worked out.
No, if that 82,000 was paid immediately,
Ah.
I said I'll reduce the interest little. He was open for it.
In fact,
There's only 82,121 with interest at 12% for the delayed payment.
interest is, my lords, for the
Interest is
entire
o-
payment, 3,82,121
2,000.
for almost 16 years. my lords.
Ah.
12% is very high, my lord, it may be.
That's
10
the
or
government order,
6%
my lord.
Huh?
Government order, annexure T.
Anyhow, in case you find there's a lapse, then you take action for recovery again. So which is the government order?
Annexure V, page 87, my lords. This is a government order dated 17/6/1995.
Yes,
12% interest, my lords.
just read it.
Second unnumbered paragraph, my lords.
Yes.
Government are pleased to clarify that the orders issued by government order so-and-so dated so-and-so enhancing the interest rate on belated payment of pension, DCRG and encashment of leave to 12% has come to effect from 13/9/1994. Interest at 12% per annum is payable on belated payment of pension, DCRG and encashment benefit in respect of cases of retirement on or after 13/9/1994, subject to the conditions specified in the said government order dated.
You retired?
My lords, I retired in 2009, my lords.
Yes. What is the reason for the delay?
My lords, the pay fixation, my lords, since I was appointed as a physical instructor in the year, my lords, 1974, there was some issue regarding pay fixation, my lords. Subsequently, my lords, in the year 1994, or with effect from 1994, the pay was fixed at 14,960 minutes. That was an issue, my lords, which was under consideration. Therefore, my lords, my salary was not settled in spite of me having retired from service in 2009. And this honorable court, my lords, also passed an order at Annexure S, page 83.
This is a writ filed by you.
This is a writ which was filed by me, my lords, wherein the government was directed to consider the case of the petitioner, keeping in mind the notification on 21/12/1994, which fixed the pay scale as 14,940.
But because of the pending litigation, there may have been some delay.
No, litigation is not at my instance.
Litigation?
Is not at my instance.
So the writ was filed for what? For fixation.
For fixation of payments. The first writ, my lords, will get it at Annexure L, page 41. This writ, my lords, I had filed it in the year 2005. This is a division bench order. This went against me, my lords. The operative portion of the order, my lords, is at page 64.
Yes.
The writ appeals are allowed. The order dated so-and-so passed in WP number so-and-so and so-and-so is set aside, and the matter is remanded to the second appellant to reconsider the same for fixation of pay in the light of subsequent UGC order dated 19/10/2006 and also government order dated so-and-so in accordance with law within a period of 2 months. So therefore, my lords, there was a direction in the year 2011 itself, by which time I had retired. But this was never done.
Till
they paid me, my lords, only about 5 months back.
so despite this order, they have not.
They haven't done. So delay is not on my part. Even taking this order into consideration, my lords, there's a delay of
Now,
about
so,
13 years.
You are seeking interest
On 3,82,121 for a period of 14 years.
3,82,000.
121.
We can take it after from 6 months after the writ appeal. From
Please,
then. 6 months from the writ
please.
appeal.
Can be taken as 1st January 2012 also.
So they paid, cleared it on?
My lords, there was an order on 16/11/23. They paid it, my lords, in the first half of 2024. I'm not aware of the exact date, my lords.
Yes. So from the, from 1 year after the, from about 6 months, 8 months after the writ appeal order.
Till the
interest-
passing of annexure T, my lords.
Till the
Passing of order at annexure T, that is 16/11/2023.
What is that?
That is the order where, my lords, they actually fix my pay scale and say that I am entitled for retirement benefits of 3,82,121. And out of which they pay 3 lakhs and the balance 82,121 is held back by. That, my lords, will get it at the second unnumbered paragraph.
No reason why they have withheld it.
No, my lords.
Huh? But under the order, they say full amount.
They
is
say, my
payable.
lords, but what is paid is 3 lakhs. My lords. I can file an affidavit to that.
Yes. The petitioner.
This matter was handled by my colleague. My colleague is appearing in this matter.
No, correct. So we'll pass. I'll not sign the order. If there's anything tomorrow or day after tomorrow, he can make submission. I'll release it after hearing, but that's all. There's no. The petitioner was stated to have been appointed as a
Physical culture instructor at that point in time in 74.
physical culture instructor
On 3/8/1974.
It is submitted that in light of extension of UGC pay scales as per the government order dated 12/12/1994, the petitioner's salary was to be refixed.
Please.
Full stop. Next. It is noticed that the refixation did not, that the refixation took time and was involved in a litigation which finally culminated in the writ appeal 234 of 2007.
Please.
Disposed of on 29th April 2011. Full stop. And despite such refixation, as per the order of the division bench, it is only on 16/11/2023 that the pay of the petitioner was refixed. Full stop. Next. He submitted that petitioner had attained superannuation on
My lords, in the year 2009, my lords.
in 2009.
Please.
And in light of withholding of his superannuation benefits for an unduly long period of about 13 years,
14
years. Petitioner is seeking for payment of an amount withheld as well as interest on the amount of a superannuation benefit which was paid belatedly. Next. It's a matter of record that writ appeal 234 of 2007 was disposed of on 29th April 2011. Operative portion of the order, page 64-65, reads as follows. Full stop. the time that was granted for the state to determine the refixation of pay in light of the UGC order dated 19/10/2006 and government order dated 4/7/2008 was a period of 2 months from the date of receipt of copy of the order. Despite the order having been passed on 29th April 2011, the refixation admittedly was pursuant to an order on where do you get that date? T, isn't it?
T minutes. 86.
Was as per the order at annexure T on 16/11/2023. It is further to be noticed that petitioner claims that an amount of 3,82,121, though quantified, only an amount of rupees 3 lakh has been paid as on date. Full stop. Next. It must be noticed that the government order dated 13 September 94.
No, my lords. That is 17/6/1995. The
Hmm.
date, my lords, is at the bottom.
It is noticed that government order number FD within bracket SPL 92 PN 95 dated 17/6/95 provides for payment of interest at 12% on delayed payment of pension, DCRG, and encashment of leave. Next. In light of the admitted facts and taking note of the direction of the division bench, following order requires to be passed. Next. The respondent number?
Respondent number 2, my lords.
2 is directed to verify assertion regarding withholding of 82,121 and if found to be true, said amount to be paid within 3 weeks from date of receipt of certified copy of the order. Next. Insofar as belated payment of superannuation benefit of 3,82,121.
Please.
Said amount would have to be paid with interest at 12% to be calculated from 1st of January 2012 till 16/11/23.
Please.
Full stop. 1st of January 2012 is taken after providing a reasonable period from the date of disposal of the writ appeal. Full stop. Next, it is made clear that if the authority, if the respondent authority is of the view that delay is attributable to omission on part of employees bordering on misconduct, it's open to the respondent to initiate proceedings for recovery, which would go a long way towards ensuring accountability in cases where superannuation benefits are not disbursed with due dispatch. Accordingly, petition is disposed of.
Well,
Yes.
it's compliance in 3 months, my lords.
The compliance as regards the payment of interest and remaining amount of superannuation benefit as observed above is to be completed within a period of 3 months from the date of receipt of certified copy of the order.
Right.
Yes.
To transfer. Lord,
Yes, KPTCL, who's there?
Lord, I have served upon my Lord Mr. Chandrachud.
Just call him, just call him.
He is. Lord, Lord, the petitioner.
You appear for?
Lords, for the case.
Lord, the argument of the petitioner in that case, I would adopt here, Lord, page, Lord, 37, Lord, I was posted to the present place at Chandapura on 9/12/2022. 9/12/2022. In the place of, my Lord, one Mr. Chandrasekhar MB. Present petitioner was posted to Chandapura, my Lord, on 9/12/2022 in the place of one Mr. Chandrasekhar MB. Chandrasekhar MB was without posting, my Lord. Lord, he approaches this honorable court. This honorable court grants an interim order on 13/12/2022 solely on the ground that, Lord, he is without posting. He is asked to report before the, Lord, KPTCL. On that ground, my Lord, page 40 is the interim order. Though he has completed the tenure, but in my case, my Lord, I have not completed. But page 40, last paragraph, my Lord, since the petitioner is not provided with the posting, annexure so and so, he stayed for a period of 4 weeks.
By virtue of this order, your transfer to Chandapura was stayed.
Stayed. Lord, my transfer is at page 37. Chandrasekhar MB was asked to report before the KPTCL. I was posted to his place. It was stayed. Then, my Lord, ultimately, my Lord, the writ petition was disposed. I took charge on 10/1/2023. Lord, my tenure ends on 10/1/2025. Apart from that, Lord, the impugned order is at page 67. Lord, the private respondent number 4 is posted, Lord,
page
67. Lord, the private respondent number 4 is posted to my place at Chandapura. Lord, I am rendered without posting. It is premature and, my Lord, without posting. My Lord, your Lordship may kindly see the Uleka. Uleka is, my Lord, the note put up on 19/11/2024 by the Honorable Chief Minister. Lord, this Honorable Court has held that, my Lord, page 70, Lord, file should emanate from the competent authority to the office of Chief Minister and not vice versa, my Lord. That is the, my Lord, direction issued by this Honorable Court at page 73, para 5. Lord, file should be built in the office of, my Lord, Managing Director of the corporation, and it should be sent to the, my Lord, office of the Honorable Chief Minister for his approval. Lord, it is not other way around, is the, my Lord, law laid down by this Honorable Court, which is affirmed by, my Lord, Honorable Division Bench. This order, my Lord, my Lord, now 19/11/2024, my Lord, the Honorable Chief Minister gives a letter to transfer the, my Lord, respond number 4 to my place. I am rendered without posting. Lord, this Honorable Court, my Lord, at page 120 has considered this aspect my lord, there are circulars issued by the state government that, my lord, there cannot be, my lord, transfer without providing a posting. Despite that, my lord, your lordship may kindly see, my lord, page 123, para 2. Despite, my lord, the repeated direction of this honorable court, my lord, the very same mistake, the only point that requires to be considered is as to whether the order of transfer after the period of general transfer could be upheld where no order of posting has been shown as regards the petitioner. Lord, your lordship will find the reasoning at para 3, page 125. It is clear that position of law is settled that passing an order of transfer without showing place of posting would suffer legal malafide. My lord, that is the law laid down in, my lord, Seema's case. This position is reiterated by the division bench of this court in the latest decision in so and so. It is also to be noticed that this is the stand of the government as noticed from the circular dated so and so. Then, my lord, your lordship has given a direction, my lord, at page 128, para 7, there should be a strict compliance of those circulars. There cannot be any transfer without providing a posting. But the impugned order is, but again, I am rendered without posting, premature, and there is no approval of the Honorable Chief Minister. But the minute is different. Lord, your lordship may kindly come to, my lord, page 90. Division bench of this honorable court has held that, my lord, minute of the Honorable Chief Minister is one thing. Approval of the Chief Minister is a prior approval of the Honorable Chief Minister is another. Lord, that fell for consideration, my lord, before this honorable court. Lord, para 14 at page 99.
But you have verified the file.
There is no approval, my lord. Lord, there is a minute of the Lord, I am consciously saying, Lord, there is a minute of the Honorable Chief Minister for transfer of, my lord, private respondent to my place. That is not sufficient. There should be prior approval of the, my lord, page 101, my lord. The division bench order starts from 90, but this honorable court says that it is only a recommendation. It cannot be in, Lord, in tune with the, Lord, prior approval as contemplated under transfer guideline. Page 101, my lord, in the middle, Lord, 11th line, my lord, we would find that
Yes.
letter of communication addressed by the Chief Minister was only a request to consider the candidature of the respondent for to the said place in question, subject to verification.
Yes, Chandrachud.
There is no approval of the honorable.
I'll just the compliance
Lord,
of
it is,
the requirements under law.
But I would adopt the argument of, my lord, my learned senior counsel, my lord, made in the earlier.
I'll address each one of them, my lords. Lords, the last things first. The judgment which he was referring to at page 101. Lords, may kindly take the judgment, my lords.
Let us see. Yes, Chandrachud. No, we have said how many times we have told, don't, without posting order, don't do it. You make a mockery of it. It amounts to contempt, that's all. Are you not aware of series of orders saying don't transfer if you don't give order of posting?
Submission.
24 days.
So what?
So that is one aspect. The other aspect with regard to the Chief Minister's concern. The file is submitted from the office of the respondent operation. And the approval has been changed. Following the due procedure as contemplated in the transfer guideline is what has been given to me to the primary instruction.
But why you have not given him posting?
One thing, when in fact it is verified as the respondent was without a posting for the past 3 months. And this petitioner was getting 4 months. This petitioner was
Complete the tenure.
completing his tenure.
ಆಯ್ತು ಇನ್ನು ಒಂದು 6 ದಿನ.
6 ದಿವಸ.
My lord, that may not be correct, my lord.
ಅಲ್ಲ
My-
ಇವತ್ತಿಗೆ ಮುಗ್ದೋಗಿದೆ.
ಇಲ್ಲ ಇಲ್ಲ ನೋಡ್ on facts, my lord, on 10/1/2023, my lord, I have taken charge.
Lord, is taken charge on 12/12/2022.
No, that
No,
may not be correct.
Just
That
a-
may not be. Lord, on facts, my lord, let them place.
It's there on record.
Place it on.
That was stayed. My lord, where is the question of me taking charge when this honorable court has stayed? But I have produced the interim order.
No, your tenure gets over when according to.
Lord, 10/1/2024,
Lord, it will be over on
2025.
12/12/2024, it will be over.
10/1,
Lord, I am sorry to say.
10/1.
10/1/2025. Lord, they are calculating from the date of transfer, which was stayed by this honorable court, which is at page 39.
That's-
My lord, it is a matter of fact.
Lords, it's a misstatement, to say the least. The order of transfer was dated 9/12/2022. He takes charge on 12/12/2022. Interim order was granted on 13/12/2022. Chamundi Moppet says that the order will not get obliterated. It is kept under suspended animation.
No, all
That
this
application
transfer-
came to be dismissed. My lords, he has taken charge on 12/12/2022.
Correct, in transfer matters, what is done.
Lords, I just wanted to say this, my lords. Now, page 101, the last things first, if your lords were to see, my lords, the reliance of each one of the judgments actually is in my favor. I'll just demonstrate from the very judgment, my lords.
Let us see, but if it is okay, then it's deferred till 10/1/2025, there ends the matter. It will come into effect.
My lords, the
After
question
all-
of 10/1/2025 is based on his statement, my lords, that he is taken charge on that day. The biodata clearly indicates he's taken charge on 12/12/2022.
But that is absolutely, my lord, wrong statement. Kindly come to page 50. Lord, on facts, my lord, I am sorry to say this.
Chandrachud,
Page 50, my lord, the final order of this honorable court says, no, you implement the transfer order. Lord, can, my lord, private respondent, my lord, argue contrary to the judgment of this honorable court? Lord, page 50. The writ petition number so and so is disposed of without disturbing the transfer order dated 9/12/2022, but calling upon so and so to issue appropriate orders, even without waiting for certified copy of the order, to issue transfer order that would enable so and so to report duty as executive engineer.
ಅವ್ರು
Pursuant,
ಚಂದ್ರಶೇಖರ್ ಅವ್ರಿಗೆ
Lord, pursuant to which, Lord, page 52, 10/1/2023, Chandrasekhar MB is relieved. Lord, can I take charge on December 2020?
anyhow, I think we'll give a quietus to this. Let
But
it be-
on facts, my lord,
Lords, I wanted to say this, my lords. If your lords want to ascertain the facts, because there should be no, my lords, disturbance on the facts as it has already taken place. If he makes a statement that on 12/12/22 there is no taking over of charge, my lords, I'll produce those documents.
I have taken charge.
Please,
Thereafter,
I wanted to complete this, so don't make the misstatements. I have documents
No,
to
no,
show that he has taken the charge on 12/12/2022. And my lords, if your lords were to see, the petition is BC Lokesh. He wanted to read page number 50 to say that the direction was given for the purpose of him being posted. That's not correct. Lords, this was a direction for the purpose of Chandrasekhar being posted elsewhere.
Of your record, what is the position you verify?
12/12/22.
I'll have it tomorrow. You verify.
Lord, I on 12/12/2022, I had taken charge. Lord, pursuant to the interim order, 13/12/2022, my lord, MB Chandrasekhar again took charge. Lord, let it be verified, my lord, by the corporation. 12/12/20, my lord, I would concede on facts, my lord.
I'll pass over just ascertain from both of them. And you call up your office and.
The biodata, this is the
So that's, this is why I should decide. Now you are the sole repository of the records. Now you take note of it. Only one submission they're making, that though the order was passed, it was stayed for a particular period of time. Now what is the general practice? You are aware. You just discuss with them, make a submission, there ends it. I'll defer it till that completion of tenure, there ends it.
Lord, Lord, without posting amounts to, my lord, legal malafide. Lord, therefore, my lord, what I would say, my lord, let them, my lord, redo the exercise afresh. Lord, let them provide a posting. Lord, without providing a posting itself is a ground for quashing the transfer order, is the law laid down by this honorable court, my lord. I am not given a posting itself is a ground. That is what, my lord, the judgment of, my lord,
So
this
correct.
honorable court.
Now
In-
in effect,
Please, my lord.
we are saying that the Order of transfer will be kept in abeyance till whatever days.
Till 12/12/2024.
Whatever. So there ends the matter. That you verify. Pass it.
12/12/24.
May be taken up tomorrow in the first round.
Deal is the matter tomorrow.
Please,
You
Vilas.
just ascertain.
But in the fresh matters list. my
Yes,
lord.
in the fresh matters. But don't bring this argument in court. You have to settle whichever date, you sit with them and settle. I'm not going to spend time on it. Next. No, that you sort it out, that you sort. Yes. Next. No, I get irritated sometimes it's transfer matters. So I'm saying you sort out this. Yes.
But the without posting is also my lord
No,
required.
correct, but so we'll see.
Please.
That you will have to give an undertaking. Now, if this is deferred till the tenure, by then you must give him a posting. By then.
But till
By
posting is given, my lord, the transfer order may be deferred.
No, we'll see that you have to undertake. Ms. Chandrachud will have to undertake upon instruction that the transfer order will be given till by the day till when it is deferred. Yes, next.
29.
For petitioner, Lord, the petition by the president of SDMC. The specific contention, my lords, was that there are 10 posts of sanctioned teachers in government school, where, my lord, the petitioner is the SDMC, my lords, in Anikal. Out of which, my lords, 5 are already, my lords, vacant. And, my lords, of the rest 5, my lord, 2 were transferred. And as such, my lord, this petition was filed. Now, my lord, the statement of objection is preferred by the state, saying that, yes, there are 3 regular teachers, but 3 honorary teachers and my lords who are sent from some organization. And my lords, 3 teachers, my lords, who are on a part-time basis. My lords, the institution requires, my lords, regular teachers. My lord, they cannot, my lord, put some honorary teachers and ask, my lord, the class to be conducted in a government school, my lord, where the government has the responsibility.
We don't know how many staff. Okay.
My lord, I can show, my lord.
Take
Yes.
your lordships to the statement of objection. My lords, firstly, if your lordships turns to page 15, annexure R4 of my statement of objection. This is a document that discloses the number of vacancies, my lord, teachers. Your lordship sees at serial number 4 at the table, sorry, 5, my lords, Anikal, it is 269, my lords.
269,
469 vacancies, my lords, in Anikal.
for which you have,
Shakara Sanke.
so you have
I'm sorry,
utilized guest lecturers
65 not Anikal.
wherever there were vacant posts.
Now there's shortage of teachers. What the petitioner is asking for now is deputation of permanent teachers, my lords. Now, when there's the number of teachers itself, there's a shortage of teachers, and among the ones available, we have assigned. There are 3 permanent teachers at the school at the moment, my lords. Now, if your lordship turns to annexure R6 at page 24, my lords. This is a report. The lordship sees at the bottom. Ilakeya Shikshakaru, permanent teachers are number 3. Ilakeya Atiti Shikshakaru, number 3. And Sansara Company Shikshakaru, that is, those are the teachers assigned by an NGO, my lords, those are number 3. So as against the sanctioned posts of 10 teachers, presently there are 9 teachers teaching at the institution, my lord. Now, even if there are guest teachers pre-appointed on a contract basis, the state is paying their salary, my lord. Now, to ensure that there are no shortage of teachers, because we are given only 269 teachers so far. Now, to this school, that the school is not inconvenienced, an NGO came forward saying, we'll provide teachers, 3 of the teachers, and we'll pay their salary. So that same is approved by the DBPI. Now, 9 teachers are teaching at the institution, my lord. This document would show that contrary to the contention of the petitioners, there are about 9 teachers presently teaching at the school. The only grievance of the petitioner is that they are not permanent teachers, my lord.
It may not be so,
I
my
would
lords. It may not be so.
submit, my lords, that there's difficulty wherever we have faced, we have tried to make adjustments, and we have appointed teachers on a temporary basis, as well as taken teachers assigned by NGOs who have come forward to appoint teachers, my lords. So I would submit that the students are not inconvenienced in any way. Also, my lords will see what the petitioner is saying is that we have ourselves transferred the teachers. Now, yes, there was an order for transfer in the month of, in the 7th month of 2023, my lords. Pursuant to which there was a inspection conducted of the institution, where it was found that yes, owing to the transfer, there will actually be shortage of teachers. So we say we'll hold off on the transfer until there are further teachers appointed to the school. No teachers are to be transferred. But however, it is found, my lords, I have produced the documents. The school itself relieves the teachers transferred. Now, this is not on the ground of transfer as ordered by the authorities, but because there is a counseling in another institution and the teachers themselves asked to be relieved because they want to go to the other school.
Where is that?
No, it may not be, my lords. In fact, my lords, just, I'll take my lords 2 minutes.
Just wait.
Please, my lords. Contrary sub, my
Just
lords.
wait, I'll come to you.
Next, R1 be the report that is also referred to by the petitioner, my lords, at page 7, dated 6/8/2020. If your lordship sees last para, ಸದರಿ ಶಾಲೆಯಲ್ಲಿ ಒಟ್ಟು 10 ಹುದ್ದೆಗಳು
You're
ಮಂಜೂರಾಗಿ
reading at
page 7, my lords, the last para. And
Page
next R1.
7.
Yes.
of
next
your
R1.
statement of objection, inspection report.
Yes.
Yes.
ಸದರಿ ಶಾಲೆಯಲ್ಲಿ ಒಟ್ಟು 10 ಹುದ್ದೆಗಳು ಮಂಜೂರಾಗಿದ್ದು ಮುಖ್ಯ ಶಿಕ್ಷಕರ ಮತ್ತು ಸಾರಿ ಮ್ಯಾಮ್
ದೈಹಿಕ
ದೈಹಿಕ
ಶಿಕ್ಷಕರ
ಶಿಕ್ಷಕರ ಹುದ್ದೆ 5 ಶಿಕ್ಷಕರ ಹುದ್ದೆ ಖಾಲಿ ಇರುತ್ತದೆ. 5 ಶಿಕ್ಷಕರಲ್ಲಿ ಶ್ರೀಮತಿ ರೂಪಾದೇವಿ ಹಾಗೂ ಶಶಿಧರ್ ಎಂ ಅವರು something.
Produce the type copy itself, my lords, at page number 40 of the
Hold on.
petition.
Page
Number 40, 40, Manekshara D.
paragraph.
My lords may have a look at second paragraph.
No, but now I'm just asking before we enter into
Please.
merits. Now the distribution of staff is left to the government. If there are 269 vacant posts, they have the priorities. We don't know
Yeah.
how many other schools have got
My lords,
similar
I'll make,
difficulties.
my lords, let me, that's why I said, my lords, some submissions which are contrary to the records are made. Annexure D, my lords, I'll read it. It reads, my lords, Sadari Shaleli, ಒಟ್ಟು 10 ಹುದ್ದೆಗಳು, the submission which was made, my lords, that they have the teachers. 10 ಹುದ್ದೆಗಳು ಮಂಜೂರಾಗಿದ್ದು ಮುಖ್ಯ ಶಿಕ್ಷಕರ ಹುದ್ದೆ ಮತ್ತು ದೈಹಿಕ ಶಿಕ್ಷಕರ ಹುದ್ದೆ ಸೇರಿ 5 ಶಿಕ್ಷಕರ ಹುದ್ದೆ ಖಾಲಿ ಇರುತ್ತದೆ. 5 ಶಿಕ್ಷಕರಲ್ಲಿ ಶ್ರೀಮತಿ ರೂಪಾದೇವಿ ಹಾಗೂ ಶಶಿಧರ ಎಂ ಅವರು ಸಾರ್ವತ್ರಿಕ ವರ್ಗಾವಣೆಯಲ್ಲಿ ವರ್ಗಾವಣೆಗೊಂಡಿರುತ್ತಾರೆ. ಉಳಿದಂತೆ 3 ಶಿಕ್ಷಕರು ದಟ್ ಇಸ್ ವರ್ಗಾವಣೆಗೊಂಡಿರುತ್ತಾರೆ, my lords, is the statement made. ಉಳಿದಂತೆ 3 ಶಾಲೆಗಳಲ್ಲಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಿದ್ದು 2 ಅತಿಥಿ ಶಿಕ್ಷಕರು ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸಿದರು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ವರ್ಗಾವಣೆಗೊಂಡ ಶಿಕ್ಷಣ ಬಿಡುಗಡೆಗೊಳಿಸಿದಲ್ಲಿ ಶಾಲಾ ಮಕ್ಕಳಿಗೆ ಶೈಕ್ಷಣಿಕ ತೊಂದರೆ ಕಂಡು ಬಂದಿದ್ದು ಸದರಿ ಶಾಲೆಗೆ ತುರ್ತಾಗಿ ಶಿಕ್ಷಕರನ್ನು ನಿಯೋಜಿಸಬೇಕಾಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಸದರಿ ಶಾಲೆಗೆ ಹೆಚ್ಚುವರಿ 3 ಶಿಕ್ಷಕರು ನೀಡಿದ ಮೇರೆಗೆ ವರ್ಗಾವಣೆಯಿಂದ ಶಿಕ್ಷಣ ಬಿಡುಗಡೆಗೊಳಿಸಲು ತಿಳಿಸಿದೆ. ದಿ ಸ್ಪೆಸಿಫಿಕ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಬೈ ದ ಡೆಪ್ಟಿ ಡೈರೆಕ್ಟರ್ ಇಸ್ ಟು ರಿಲೀವ್ ದಿ ಟೀಚರ್ಸ್. Yes, once to relieve the teachers because 3 guest faculty is provided to the institution. He says 2 are transferred. Relieve them because 3 guest faculties Atithi Shikshan kottideve anta. 5.
Okay. Now we don't know the difficulties of other institutions.
Lord,
Now the allotting must be done. Now if there are 269, suppose 269
Please.
posts which are vacant.
Please.
Now the government will have to distribute equally. We don't know the situation of other schools also.
My lords, that I can, my lords, definitely, my lords, I would appreciate if they had taken us, my lords, to confidence. My lord, it is the issue that, my lords, the
Now
institution.
you see if you can sort it out. We'll direct their presence before the DDPI, whose authority.
My lords, the orders are, my lords, issued by the BO. My lords, there is order.
But who's the officer who will be in a position to look into?
Lords, it is In fact, my lord, the deputy director. my lords.
Deputy.
Deputy Director.
But all these orders are passed by, my lord, the living order, my lords, is by the deputy director. But my lord, what they say, my lords, as the honorary teachers, it is by the BO. My
Like
lords,
my reading report is different, my lords. We make an observation that yes,
No,
there are
that,
transfers.
no, we'll not enter into it now.
please,
We'll say that Deputy Director of Public Instruction.
now, my lord, school education and literacy department,
Deputy Director,
school education and literacy department, Bangalore Rural District,
School Education and
literacy department.
we'll ask him to be present on a particular day. You look into and
Please.
see, it's an administrative issue. We don't know your situation. So,
The school students are not being inconvenienced in any way, my lords. There are 9 teachers.
All are,
Regular teaching. In fact, their qualifications are also produced.
my lords,
They're
these
regular
arrange,
attending the
my lord,
attendance
these
is
arrangements are made after the writ petition was filed, notice is ordered. Before that, my lords, they are even according to the report what I have produced. On its face value, if it is taken, there are only 6 teachers, not 9. Other 3 are my lords, added subsequently. That is after the writ petition is filed.
My lords, if they are appointed, then they are teaching.
No, they are not appointed. They are, my lords,
So the-
my lords, the order says it should be by the headmaster. My lord, my lords tie up with an NGO. They send those teachers. The headmaster has to take them to duty.
but
No.
they must have regular staff.
Has signed off on the report, my lords.
Relieving order, he has only has to sign. No other can sign the relieving order. It is the headmaster because DDP,
My lords,
deputy
now
director has directed. He has done it. There is no other option.
Headmaster, my lords, the present headmaster, in fact, the report I have attached along.
There
with
is
the
no
same-
headmaster, my lord. In charge headmaster is functioning there.
Let us see,
Please.
in case you can't accommodate by any permanent, so be it.
Right.
We'll see.
My lord,
If
they have to be,
if
my
there's
lord.
any way of solving the issue.
My lords, the only apprehension is, my lords, if they give it today, because we have filed the writ petition, and tomorrow they take, take the teachers out. My lord, there'll be difficulties faced by the students ultimately.
No, no, if they,
My lords, they claim, my lords, they have the teachers provided. Ultimately, my lords, they are, my lords, guest teachers, and my lords, sent by some NGO, 3 + 3, 6 teachers. If they, my lords, because, my lord, the writ petition is filed, they, my lords, accommodated 3 more. If after the writ petition is disposed of,
no,
they take out, my lords, those teachers, again, students will be in problem.
no, otherwise we can do one thing.
Please,
That this we will say is a temporary arrangement, subject to availability of regular staff. And we'll just say you must consider whenever staff is available
Available.
to substitute them. And this arrangement to continue till then.
my lord, again, my lord,
That's
that's probably.
Only that much I can do. not
Or
beyond.
can I make, your lordships
Yes.
indicated, my lords, in the beginning, that my lords will have a, my lords, interaction with, my lords, the,
Let us see. what
my lord,
happens after
department.
the petitioner to present himself before the Deputy
Deputy
Director, School Education and Literacy Department,
My lords, respond number 4.
respondent number 4, and place his legal grievance. The respondent number 4 to examine whether steps taken as of date could be improvised to take care of grievances of the petitioner.
Please.
Relist the matter in the week commencing from. Yes.
Publish.
Yes.
Appearing for R5, my lords.
Yes.
In this case, my lord, this urgency is, your lordship I have passed the order permitting the bank to issue charge sheet. And your lordship also said that you don't proceed with the inquiry. This petitioner retired from services. Then bank invoked regulation 19.3 and extended the services till the completion of the inquiry. Now, during that period, he is entitled for a provisional pension. Now, pension has to be given. Earlier punishment has already been imposed, but the Honorable Court has stated that now we have to fix the pension, and the provisional pension has to be given to him because that he has already retired. But this Honorable Court has not permitted us to proceed with the inquiry. Now, my lord, this entire matter to come to the conclusion, my lord, let this inquiry be proceeded, let them not pass orders. By that time, this matter, as it is, my lord, there are about 4 prayers. Out of 4 prayers, 3 prayers is already over now. One is regarding personal hearing. Personal hearing, my lord, I am filing one affidavit by the bank stating that that whatever the video conference, it has been recorded because there is no procedure. That one, that this also. That is why, my lord, this if some decision has to be taken, my lord, otherwise it is very difficult. Administratively very difficult for the bank to proceed now. Now they have to pay that, otherwise that petitioner will come to the court. They have not paid the pension, provisional pension, because the bank has extended the service for the purpose of completing the inquiry. But the inquiry has not been commenced now.
My lord,
And here, this person, that person.
Let the
My lord.
proceedings go on.
That is what my.
They have not
Suspension will
produced
continue.
the pen drive, my
And the
lord.
suspension has come to an end, my lord. Now there is no suspension. He is retired from service. Where is suspension now?
It's a electronic
already
form,
come to an
my
end.
lord. It will be deleted in 90 days. 12th, it will be.
They're saying that they have not maintained it.
That I have produced, my lord. That and my lord, you are only one minute.
It's a electronic form.
Giving personal hearing by the disciplinary authority nowhere in existence in any public
No,
sector.
they're saying they have not recorded the proceedings. There ends the matter.
Yes, my lord. That is
They're
what.
saying on affidavit that they have not recorded.
Recorded the proceedings. That is true, my lord.
At para 4, they've stated the personal, in the instant case, the personal hearing in regard to proposed punishment of compulsory retirement accorded to the petitioner through video conference was not recorded. Now we cannot enter into that. That is something orally stated, which
That
you are
my
saying.
personal hearing is overly one between the disciplinary authority and the person. He will ask regarding punishment. He will come and tell, no, punishment is very extreme high. You reduce it. That is all the personal hearing, my lord. Nothing. And he will explain the problem of his family, because he cannot talk about the merits of the case during personal hearing. And personal hearing is not now, my lord, that interim measurement has been made by the State Bank of India on the Supreme Court judgment, subject to outcome of the appeal. That is also disposed in favor of the bank. Now there is nothing, because the bank would have stopped immediately, but now they are taking steps to stop this. Because personal hearing, there is no service in the as per the service State Bank officer service regulation, there is no personal hearing by the disciplinary authority. This is they have made because of the Supreme Court order. Now that case is also being disposed. This order is also I am having, my lord.
Kindly have it on tomorrow, my lord. My senior is out of state.
But let the inquiry go on.
That is all I am telling, my lord.
Let the
Because
inquiry go on.
why let the inquiry go on, and we will not impose the punishment till this is over now.
They will not,
You have
I
to pay
will
the
direct them
substance
not to, I'll direct them not to pronounce the
Yes, my lord, that is correct.
final order
Yes, that is, we will not pronounce it.
without permission of the court.
Yes, my lord.
But you participate in the inquiry.
Yes, my lord.
The order of suspension will continue.
And the suspension is not there, my lord.
No,
Now.
it's not there.
It is not there. Now, my lord, there are 4 prayers. All the 4 prayers is not over. Now, only one prayer is why bank has imposed lesser punishment. This is very surprising plea, my lord, because that.
No, just 1 minute. Let me understand. Now, the present petition has been filed seeking for setting aside of endorsement at Annexure G.
Yes, that is personal hearing.
Annexure G
is the personal hearing.
Okay, so now this, so now what is the stage of the inquiry?
No, not commenced, because your lordship has not permitted.
Now, where is the inquiry?
Charge sheet is issued. It is served.
Where is that?
Which, my lord?
Charge sheet?
Charge sheet. produced along with the objections, my lord.
Now, what is the penalty then of reduction in?
My lord, this, now, my lord, this, after, the inquiry officer found him guilty. Inquiry officer, after holding him, found him guilty. And the disciplinary authority concurred with the findings of the inquiry officer. Then because of this temporary arrangement, he gave a personal hearing. And personal hearing, according to the disciplinary authority general manager, he says he requested him to reduce the punishment. And accordingly, he imposed the punishment of reduction in grade. But normally, my disciplinary action language, removal from service, compulsory retirement, and dismissal is a capital punishment. Now, this, according to the statement, the writ petition filed by him, he says, I have committed the crime. You don't impose the lesser punishment, impose the capital punishment. Whether it happens, you have not come across anywhere like that, because disciplinary authority take into consideration is the unblemished 27 years of service, and also his submission made during on the findings of the inquiry officer. He imposed a lesser punishment.
No, now charge sheet is that?
That this pertain to previous charge sheet. It's there, my lord. Previous.
No, present inquiry. What is the present inquiry?
Present inquiry, but charge sheet has been issued. It is served and waiting for the outcome, waiting from the honorable court to proceed with the inquiry. That is all, man. That I have mentioned in my.
Third counsel for the respondent submits that the assertion of the petitioner regarding proposed imposition of punishment of compulsory retirement is not backed by any records. Full stop. Further submitted that by way of an affidavit that no recording of the personal hearing
through video conference.
The proceedings on 12/9/2024 through video conference has been maintained.
Yes,
Full stop. Taking note of such statement and absence of video, absence of recording of video conference personal hearing, it would be appropriate, taking note that the petitioners attained superannuation, that the respondent is permitted to continue with the inquiry proceedings while making it clear that no order to be passed regarding the punishment, regarding the punishment without orders of this court. The petitioner to cooperate in the inquiry proceedings.
Yes.
All contentions, however, are kept open to be decided.
Yes.
Kindly extend the IO.
What is the interim order now? What is the interim order? Now, obviously, he is not on service, only notionally he is on your roll.
Yes, my lord.
No, just 1 minute, let me understand. So, the suspension order at annexure F is in effect, not in operation.
In effect, it has already come to an end on the date of his retirement.
Correct.
So now he is not under suspension. Now he is the retired employee. And that bank has invoked the regulation and continued his services only for the purpose of completing inquiry.
In terms of the order passed today, in light of the subsequent events, including one of superannuation of the petitioner and taking note of the affidavit filed by the respondent, the interim order passed on 22/10/2024 is modified to such extent. Now, anyhow, I've said that they can't give the final order of punishment, but you participate in the inquiry. The participation of the petitioner in the inquiry would be without prejudice to the contentions raised in the present petition. Yes.
Bhargav.
For respondent number 5 in serial number 32, my lord.
I'm for the petitioner, my lords.
Yes, you finish your service, week's time granted.
Your lordships, they are only the formal party, my lords. Respondent number 6.
Then you delete it at your risk.
Your lordships, but yes, I'll furnish it within 1 week, my lords.
List week after next. Manjuna.
33.
Petitioner, my lord.
Yes.
Matter is posted last week and the preliminary hearing, my lord.
No, you take dates. I'm not taking any matter.
No, my lord.
I'm only allotting dates. I have to rise now. So I'm only allotting dates.
My lord, only sought for interim order, my lord. Another F. It is incompetent authority. The matter is covered by judgment, my lord.
Pawan
Incompetent authority.
What?
I'll serve it, madam.
One is AEE, one is AE. As far as AEE is concerned, is the group A employment.
List the matter in orders list.
34.
This also
34 same, my lord.
Same.
My lord.
35.
My lord, on submission, my lord. Similar circumstances.
35, I appear on behalf of the
The
respondent number.
Honorable KT, state employee.
No, correct. I'm having it on 10th and that day you make submission. Now I'm not hearing.
There is urgency, my lord. It is sought for interim order, my lord.
No, just one.
The matter is covered by judgment, my lord.
Just 1 minute. 33, 34 in hatra date. 9th. Yes.
35.
Yes.
My lord, serial number 35, I appear on behalf of the respondent number 3. I need to file my statement of objections. 2 weeks time may be granted, my lords.
List after 2 weeks.
Anytime after 2 weeks, the matter may be listed, my lords.
List after 2 weeks at request.
36.
Yes. List the matter in the week commencing. Yes.
36. 36.
Week after next.
37, but I am for the petitioner. Election list challenge ಮಾಡಿದ ಸಮಯ ಅದರಲ್ಲಿ ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಆ ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕಾದ್ರೆ ನಾವು 3rd B ಮಾತ್ರ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ವಿ. ಅವ್ರ ಅಡ್ರೆಸ್ ಏನು ಕೊಟ್ಟಿಲ್ಲ ನಮ್ಗೆ.
List the matter. This is a fresh matter. Fresh. List the matter in fresh matters list on 6th. Previous matter move ಮಾಡಿದ್ದಾರೆ. ಅದು fresh matters list. 36. List the matter in fresh matters list on 6th.
38.
Appearing for petitioner, my lord. Direct respondent to file objection for the main petition.
Respondent to file statement of
Other
objection.
2 connected matters are there, my lord. Other 2 connected matters, my lord.
List along
Petition number 1190 bar 2020 and writ petition number 37087 bar 2014, my lord.
Huh?
37087 bar 2014.
37087
bar 2014
Yes, and the other one?
and 1190 bar 2020, my lord.
List along with so and so.
39.
Please, my lord.
What is the urgency? Huh? If it requires hearing, let it come after vacation. Huh? List the matter. Yes.
40. That is for PL.
List the matter in the week commencing from.
41. CH-09. 42.
42 RP for the petitioner, my lord. Kindly have it on 13, my lord.
What is the matter? What is the urgency?
The fight for direction, my lord. Petitioner's salaries have been withheld, my lord, with a bill collector. Kindly have it on 13.
Not date. Relist.
16.
Yes.
Not 16,
43.
18.
18. 43.
43 education matter, my lord. Your lordship disposed of.
I appear for respondent number 5, my lord.
Respondent number 4, your lordship.
Any day, date.
You sought for revival.
Yes, ma'am.
Relist. Yes.
44.
Is for provisional pension.
Where is Muttarna? Relist. Yes.
45.
45, I am appearing for the
44,
petitioner.
12th may be late.
44,
12th may.
12.
At 45, Lord, may I request this matter be taken up tomorrow, my lords? The reason is this, my lords, they were appointed in January 2023. Till today, they are continuously working, my lord. Their salaries have not been paid. Single rupee is also not paid, my lord. Though there is a court at bench at Dharwad bench, my lord, has passed an order, my lord, directing the authorities to pay the salaries.
Relist.
Tomorrow, may I request in the orders list, my lords?
6.
47.
May I request for orders list?
But, yes.
47.
My lord, petitioner is a doctor, my lord. During the presidency of principal, they are not considering petitioner name for the.
B group matters date will be given. It doesn't look like B group will reach. But anyhow, dates will be given by the court officer. Make a request.
My lord, serial number
My lord,
74, my
49.
lord.
49, my lord.
No, correct. That once it comes out, you'll have to amend it and we have to hear it. Before that, we
May I
can't.
request for
Lordship,
serial number
49,
74, my lord.
My lord, serial number,
74, my lord, I mentioned it in the morning.
lordship
Only, my lord,
59.
my promotion, my lord, it's a fresh matter only. Lord, 5 posts are vacant, my lord, and still, my lord, I'm eligible for the promotion, my lord, they are not considering. Sought for writ of mandamus, my lords.
But unless they take the stand that you're
Lord,
eligible.
I have served on my learned friend, Madam Suman Baliga. Lord,
My lord, serial number
first
49.
lost to have this next week any day in the
My
orders.
lord,
Dates will be given.
my lord, serial number
request for
49.
orders.
I have already statement of objections is also filed and it is covered matter, my lord. I have also prepared a tabular form, how it is similar to the other case, my lord.
Just,
My lord, it may be.
just wait, just wait 1 minute. 47. Relist. Now this has to be heard on merits. 47.
47.
Relist. Yes.
My lord, serial number 48, praise for 2 weeks time, my lord, for filing the statement of objection, my lord. 48, my lord. Serial number 48, my lord.
Just wait.
Sorry.
Now on what ground you have withheld? On what ground you have withheld the family pension? Yes,
lord.
counsel.
My lord,
Please unmute. On what ground you have withheld the family pension?
in this case, my lord, the departmental inquiry, there is more than close together rupees is misappropriation, and moreover, the petitioner daughter is already working on the basis of the compensatory ground, my lord. I will file the statement of objection.
Let them file their statement.
Yes, sir, my lord. 2 weeks time may be granted, my lord. I have not received the departmental inquiry report, my lord. And moreover, the petitioner daughter is already worked as a.
Your daughter is working on compassionate appointment.
Yes, sir, my lord.
Statement of objections to be filed by the next date. Taking note that statement of objections have not been filed despite the matter being of the year 2022. If statement of objections is not filed by the next date, respondent to deposit costs that would be quantified by the court. Relist the matter in the week commencing from. Yes.
49.
My lord, serial number 49 regarding regularization, my lord. Since 1994, we are fighting this matter, my lord. All of them have been regularized and it is covered by judgment, my lord. I have also prepared a tabular form, how it is same, my lord. And also the judgments are also furnished, objections also.
The matter in the orders list on.
16.
Obliged.
Serial number 50. 51. 52.
52. Ah. It's the matter in the orders list on 17.
53.
The seniority list has been challenged in these proceedings. Now, on the basis of the question, the seniority list promotions are also being granted. Pleadings are complete.
This is the matter in the week commencing from
13th of 54.
Lordship, so the petitioner, Lordship, kindly may be listed tomorrow.
what is the urgency?
Here, the petitioner is a senior citizen.
Yes,
The petitioner is a senior citizen.
yes, yes.
Proceeding that is against him, it is not getting listed for the last 3-4
No,
days.
this is that pension,
Yes, yes, sir.
Air Force, Air Force.
Yes. Kindly tomorrow it might be taken up in the initial. list.
Relist tomorrow in the orders list. Now, the rule doesn't provide for withholding
Yes, sir.
till only if there's a final order passed.
Yes.
Huh?
Yes.
Uh,
We have
tomorrow.
filed an application that Lordship kindly tomorrow.
Relist the matter in the orders list tomorrow. Yes.
55, my lord, may I request for tomorrow, day after, my lord, for this reason, my lord, termination has been challenged. And without employment from 2 years, my lord, there's some urgency because she's not got and asked for back pages also, my lord. Can be heard, my lord.
Whether writ jurisdiction can be exercised in itself is brought into question because I'm not state.
Lord,
I
it
don't
can be
follow
heard,
the
my lord.
definition.
This is why I'm asking for tomorrow or day after.
Directly they have come.
They have come directly.
No, directly, and my
Termination
lord,
that
for
is
me,
termination under a private employment agreement that is being challenged here.
226 is maintainable, my lord. That I will.
What is the remedy available?
Remedy available would be, well, it's a employ for whatever recoveries, a civil suit is maintainable.
No, now it's a disciplinary proceedings or punishment imposed.
Termination, my lord. It has already been terminated.
There is service of 2 months notice period or salary in lieu of those 2 notice periods. Here we have given her salary for 2 months.
So correct, according to you, if a writ is not maintainable, under your service rules or otherwise, what is the, where is the remedy? Where the remedy?
From civil suit to
Civil suit. Relist the matter in the week commencing from.
30.
My lord, may I request for tomorrow, my lord? She's without employment, my lord.
No, correct, but then if these
Lord,
are the questions.
My lord,
we
I will
can't-
prove that, I will prove it, it is applicable under 226, my lord. That is why, that is what I want to argue in this matter, my lord.
Let us see.
It
let
is a
us-
government subsidiary body, my lord. It's not a private body at all, my lord. That I will show, my lord. That I will show. It is a government subsidiary. ONGC is a government subsidiary body, my lord. That I will
It
show.
requires some consideration.
My lord, may I request for at least next week, my lord?
Right, no,
Next week, my lord.
no,
In the orders list, my lord, may I request?
it will come.
56.
Much of this.
56.
In urgency, what is urgency? Relist. Yes.
57. 58.
58 may not appear for petition of conference, but in this case, salary was directed to the minister in the month of October 23, during which direct appeal was asked to be present before them. Thereafter, they filed a objection containing so whatever has been approved has been taken. It is amounts of contempt and is not maintainable.
They're not paying, they're not paying salary.
No, sir. These- Director, we vote then. Now, not paid, I send it petition in the writ petition on 11th October.
It's the matter in the orders list.
My lord,
Orders.
in this matter, we filed a statement of objections, my lords. I would only say that there's been an inspection. It is found that the petitioner was not in attendance for that particular period for which it has not, we've not released funds, the state.
This. Occasion. There was no-
Let us see, anyhow, pleadings are filed.
Yes, my lords.
Relist the matter. No. Yes.
59.
59, I'm for the petitioner, your lordship. It is regarding payment of interest over the arrears of salary paid, your lordship. There's some urgency, your lordship may kindly fix any date, your lordship.
Interest on arrears.
Yes, arrears of salary. Arrears of salary was paid, your lordship.
Paid.
Interest after 7 years, they've paid, your lordship.
We'll consider. List the
Yes.
matter in the week commencing from.
May I seek in order for
Note an idea. Yes.
60?
Number 60, my lord. I'm seeking only a mandamus. Next week, only mandamus, my lord, if time permits.
Note. Relist.
18.
In
61?
in the orders, my lord.
Barely note on it.
61? 62? 63?
Please, my lords, in this, I'd express some urgency, my lord, because there is a transfer of a Anganwadi worker. She has 2 minor children and ailing father-in-law.
List the
There is a-
matter in the orders list.
If list, please,
17?
please, I'm grateful.
65? 66? 67, 68, 69?
Lord, I'm for the petitioner, my lord. Any date before the vacation.
What is urgency?
It is a pension case, my lord.
Pension is not settled.
No.
Relist. In orders list on. Yes.
70?
Apply.
71, 72?
72, my lord. The legal services authorities matter, my lord. The lordship may.
Relist.
Election matter, my lord. The election.
Relist on. Selection is, process is over.
Election process is over, my lord.
You have challenged?
Is challenged.
Challenge the selection.
Yes.
Matte raja admel badi.
13?
Yes.
Please, my lord.
73?
My lord, I'm for the petitioner in this case, my lord. Petitioner had applied for an application for supervisor post, my lord. In this, in primary list, she was selected, my lord. In final list, she was rejected, my lord, on just on the basis of residential purpose, my lord.
Let us see. Relist the matter in the
Next week, my lord.
commencing from.
My lord, she's unemployed, my lord.
Correct. Somebody is now selected. So if we have to displace that, then we have to hear and displace somebody.
Before vacation, my lord.
Let us see. Let us see.
No, she's unemployed, my lord.
Let us
74, my lord,
Hmm.
not for writ of mandamus, my lord.
3 weeks time may be granted, your lordship.
Huh?
I
Mandamus and the
will file objections, my lord.
list the matter in the orders list.
The 5 posts are vacant, my lord. I am eligible, my
Orders
lord. They are
list.
not considered.
70?
Please.
21? 75?
List the matter in the orders list.
17? 76?
Petitioner, my lord. Lord, petitioner was retired in the month of January 24, my lord. Without holding inquiry, my lord, entire retirement benefits have been withheld by the corporation.
List the matter in the orders list on.
12?
Apply.
77?
I appear for petitioner, my lord. My lord, I have challenged the rejection of my selection, which
Let us see.
permission granted to which I am belongs to my lord.
Let us
Next,
see.
my lord, any date may be, my lord.
Pleadings must be completed and we have to hear the matter.
Any date may be given.
List the matter in the week commencing.
78?
78, my junior has been promoted. January one date kotra sir.
List the matter in the week commencing from.
13th of January.
80?
Any specific date may be.
Good. Good.
Reporting.
81, 80, serial number 81. 80, 81 date ಕೊಡಿ.
Sir, 79 ಏನಾಯ್ತು?
ಎಷ್ಟೇ ಸರ್?
Manju sir.
ಮಾಡ್ಬಿಡಿ ಸರ್ ಅಲ್ಲಿ ಫೈಲ್ ಅಲ್ಲಿ ಮಾಡ್ಬಿಡಿ.
Sir, 79.
ಸೀರಿಯಲ್ ನಂಬರ್ 80. 13th of January, sir. 13th of 81. 81 before vacation. 13th January, specific date. 8 serial number 81 ಅದು ಕೂಡ 13th of January.
79.
Sir.
Sir, 79.
ಮಾಡಿದ್ರಿ?
ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಅವರೇ ಸರ್ ಸರ್
ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಅವ್ರೆ
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 79 77 ಡೇಟ್ ಗೊತ್ತಾಗಲಿಲ್ಲ. ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಂಬಿಟ್ರಲ್ಲ ಸರ್. ಮಂಜು ಸರ್.